similar eviction matters, 16 number. My lord, can it be accommodated today? That there is urgency, my lord.
Huh?
Eviction matters, my lord. Can it be accommodated today, my lord, as unlisted matter?
Unlisted?
Yes, my lord.
Yes, yes.
Yes, my lord. Deeply obliged, my lord.
Yeah, please, Your Lordship. With the consent of the other side, Lordship, I beg to mention item number 23. It may be password for today only. I have some personal difficulties. Let it be taken up on Tuesday, next Tuesday. 23.
What is the urgency? 2021 matter.
Lordship. But I have some.
Kindly fix, I'm for the petition item number 23, Lordship. And
20?
3.
Urgency.
Lordship, kindly fix it on 12th of September, Lordship.
12th. Okay, at the request of the Learned Council of the NHIDCL, matter stands adjourned to be listed again on 12th of September.
Offline.
My lord, in item 33, we have filed an affidavit yesterday. That matter, my lord. So that has to be brought on record, my lord.
You are?
Yes, yes. my lord.
No, item 27 million. Part on today million. One senior has been engaged with the party. So maybe taken on either on 5th or 5th.
What is the matter about?
Regarding land.
Land, obviously. This court is sitting on land only matters. Tell me, what is the matter about?
Actually, our proposed land, we have partial land, and that is the river eroded the land. Erosion was there for some years, and our lands will without any notice informed without any case, case, our land has been shown here it is in the government land. Now we claim that it should be corrected in our name, but they are not correct. That is the case.
So you want an adjournment?
No, either on 5th or not today. Any date.
No, no, no. Let it be there. This was a good case. You are taking an adjournment on the ground of a senior. Very well, engage it.
And it,
We have it after October. It's the matter after the October vacations.
Lordship, I beg to mention a matter, land eviction matter for motion tomorrow, Lordship.
Eviction? Okay.
Much obliged.
My lord, item number 29. Yesterday, my lord, I have filed my repeated reply. Let it
Bring it on.
Item 1.
Liberty,
in fact.
federal order. Interim order, if any, make it.
Deeply obliged.
The list.
Yes, state, what is your?
These are the instructions. There was a magistrate referee and also
Is this not the case where this person was killed at the on account of another patient, another person who was not had problems with his mental health, and then also he was not kept separately? Isn't this the case?
Right. that is it.
Where are the annexures to the magistrate report?
Minister reports are there. Report is there. The last.
Where is the annexures?
Fifth of August, that is the report.
Those
Oh,
days.
annex of,
Report is of
they-
25, 2016.
well,
I'm not on that. I'm asking you, where are the statements being recorded?
those are not forwarded.
And whether that person is alive, Farooq?
That is also. very-
No, did you test him? Because that is the most important aspect.
More board was
Because
considered.
you see, there was a direction by the court while granting the bail, the special care should be kept. Why he was put with all other inmates?
Because there was no separating.
So what? Then you put him in some hotel. But you can't put it the risks of some other people in danger.
Since our affidavit says, my lord, since there was no other wards, my lord, those.
Understood? If you don't have the word, you can't keep somebody who has any problem out there. This is a very serious thing. A person who is suffering from mental problems, he has schizophrenia. So if he had schizophrenia, you couldn't have kept him with other inmates. And this is the result which has happened.
Medical board was there in 26 that this incident.
Yes, Mr. Counsel, have you looked into the prison manual?
Only that.
You are asking for a constitutional thought. You have to be better prepared with Mr. Counsel. You have to come up that what happens, how a person is to be kept. Either in the police manual or it will be given in the prisons manual. As to how a jail manual. When there is a person suffering from mental disorder, can he be kept along with other inmates? If not, then if they had care, then obviously there is an infraction for which you will be you'll be entitled to some constitutional compensation on account of constitutional thought. But the question is, you have to help this or do you want this court to make the research for you?
My lord, the jail authority or government is absolutely responsible to protect the.
Understood. You are saying to be irresponsible because there has to be some basis to say. There will be 100%. There are judgments also to that effect. It's not for this court to find out this. I made it very clear in my last order. Kindly see. Have you looked into my last order? Have you taken a copy of that order? Then, very sad. You are not in a position to properly assist this court. You are asking for a constitutional thought merely by filing it doesn't help you.
For violation of their fundamental right under Article 19, subclause 1A.
In my last order, I made it very clear. It is seen that there is nothing mentioned as to whether there was any magisterial inquiry as regards the death of the husband of the petitioner. The records also do not show as to what steps were taken by the jail authorities pursuant to the directions issued to have the inmate Farooq Ahmed to be evaluated by a psychiatrist. It is seen only that there are certain requests being made by the superintendent jail for constitution of a medical board or sending a psychiatrist for examination of so-and-so. There is no materials on record to show as to why the authorities, including the so-and-so, did not send a psychiatrist to evaluate the inmate so-and-so. The materials which have been placed by the respondent do not seem to be satisfactory. As such, this court grants an additional to produce the records pertaining to an investigation so carried out on account of the death of so-and-so. This court can help you, but this court can't go and send and argue and come here again, pass the order. You have to look into it.
Psychiatric patient must not be allowed to.
What?
Admit in the jail. My lord.
Huh?
Psychiatric patient must not be allowed to admit in the jail.
Why are you saying so? There has to be some rule. Have you ever come across a book named as Jail Manual? No. Then how can I help you? Mr. Talukdar, you have to get me all these annexures.
Annexes.
This is
those are mentioned in
incomplete.
the report, man.
This is incomplete. You are asking of a person's right under Article 21 and you don't know anything. It will record to graduates. You should. Pursuant to the order dated 37/2024, Mr. B.J. Talukdar, the learned counsel appearing on behalf of the state respondents, have produced certain documents, including a magistral inquiry report. However, the magistral inquiry report does not contain the enclosures mentioned therein. The entire magistral inquiry report be also placed before this court on the next date. List the matter again on 19th of September 2024. The documents, in addition to that, an additional affidavit be also filed, bringing on record the other documents which were placed. I'll pass further another order. Let me look into another advocate. If I get hold of him, I'll appoint as an amicus because there's no chance of getting any help from this council.
Jail manual, I will also go through. what are
Because
the-
this is not the way. Because one has to take note of, if there is no rule as regards that, then we may have to implore something.
Yes.
They're saying that you cannot. That is another aspect of the matter. But if there is a rule, then we have to look into, yes, how could it happen? How can a person who is suffering from schizophrenia can be put with other inmates? I am definitely certain that there is another rule out there. There has to be something
Sure.
mentioned out there.
Jail
Because the jail manuals are very clear on that aspect. But the
and
sad
also-
part is that the council is not in any manner. Is Kostov Gogoi a panel council? Government council?
Additional senior. Additional senior government.
Additional?
Senior government.
Anyway, we'll have it later. I will fix it on here. I'll appoint somebody as amicus. Let me look into it once I ask him. Not getting in.
Item 3,
Yes. Why is this matter before me?
6. Others, 6 of the street, in fact.
Matter.
If your losses see the plain, my lord,
This is on that date.
yeah, my lord, your losses.
Then he filed a case under section 6 and the decree has been passed.
How decree is passed, my lord, that your losses first see the plain. What is the statement, my lord? Your losses see. My lord, that page 38, my lord, complaint.
Here the blame is on the lawyer.
No, I'm not blaming her, I'm,
Any other ground taken is well accepted, but blaming a lawyer, I don't like it.
I'm not.
Coming from the legal
I
fraternity.
only, my lord, want to say, my lord, the plaintiff must win the case on the basis of his own, my lord, not on the witness.
Yeah. Yes, tell me.
Plaintiff along with his brothers, namely Rajak Ali, Tajuddin Ahmed, Jamiruddin Ahmed, Mohammed Jalil Ali, were the owner and possessor of a plot of land measuring 1 bigha 1 kata, my lord, only, by your purchase of Capital of so-and-so village Amoni under police station Belso so-and-so district Assam, which is described in schedule 1 to a blame. Moreover, one Obi Deka and others owned a plot of measuring 2 bigha 1 kata 16 lija, my lord, disputing the or in respect of this land. Of the same Dag and Patta, which is described in schedule 3 of the plain. This total land of Dag of the schedule is in actual physical possession of the plaintiff since 27/9/94. So how? So nothing has been said, my lord, I shall come to that. And since that plaintiff has been possessing the land cultivating paddy, Rabi crops till today were paying land revenue. So where is that paying land revenue? For default, my lord, this land was sold in 1996. For not paying the land revenue, the land was auction sell. Auction sell.
Which land?
This entire land, my lord, Patta.
Of the Dag and Patta. that
Paying
is.
land revenue
So
is part-
schedule 2 is what?
yeah, there, my lord.
Where is the schedule?
Tell us. Schedule 2, my lord, total land, my lord, is there. Schedule 1 is the his own land, my lord. Originally, he was the
Schedule
owner,
2 belongs to somebody else.
others belong to somebody else.
Huh?
This 2 bigha, schedule 3 land belongs to somebody else, my lord. The entire Patta land was purchased by one Bapu.
And now he is asking for schedule 2.
Schedule 3, my lord. Schedule 3, which is not his land, my lord. Schedule 3 belong to my lord, one Kabi Deka and others. And how he get the position, my lord? So says, my lord, that at least there must be something, my lord, that how he came into position. And after purchase, Bapuram Bormon, my lord,
He says that in the year 1994, the plaintiff developed the land of schedule 2 for cultivation. Next para.
how? Well, how he has come into position? He says first thing,
He was lying idle. He says it was lying idle.
Asking, my lord, at least, my lord, there has to be, and moreover, he says by paying land revenue. But for default of land revenue, Bapuram Burman purchased it 1995-96. Then he got a mutation. My lord, mutation itself shows, my lord, that ownership and possession, title and possession. Without that, my lord, it cannot be. And 2016, my lord, the petitioners purchased the land. And he said, my lord, he fraudulently, my lord, got a my lord, sale agreement with Bapuram, which Bapuram wanted to for 1 bigha 2 kata for the well, this land. And this land was sold by Bapuram to the petitioners, and they also got mutation, my lord. They filed a Jamabandi. It shows, my lord, that my name is mutated. Just I'm relying on one judgment of the Supreme Court 2012, 5 SCC, my lord. Regard, my lord, at least some statements should be made, my lord. He submitted the land revenue receipts of, my lord, letter on behalf of Bapuram. For the 12 ISCC is 70.
When did Bapuram Burman purchase?
My lord, in 1995-96.
Huh?
My lord, 95-96. It's a case, my lord. Auction sale, case number 88 of 1996. My lord, it was in the judgment, there 27,997, my lord. That, my lord, I.
Including his land,
Yes,
had gone on auction sale.
everything got on auction. Then Bapuram wanted to sell his own land, my lord, but he fraudulently, my lord, entered this land to be kind. But Bapuram sold it,
So he entered into the land.
yes, my lord,
Did he enter into the land?
was there. Then Bapuram had given me the position, my lord. I had sell it also. The whole sometimes.
Let us see your written statement.
Yes.
Where's your written statement?
Statement not annexed.
Record से भाई से नहीं है। This written statement is filed by whom?
Well, by the petitioners, my lord.
Huh?
By the petitioners. Thomas Burman, sir.
How this type of written statement has been filed? That too without any verification. Let us see the Bainama,
Yes,
which is very relevant.
that is it. Panama is the file ballot.
Yeah.
The last portion of that record ballot. The last one. The last portion. I can.
Yes. This is the Bainama.
That is, number is 18.
6/6/2014.
And the-
Huh?
Yes, madam, yes.
Let's read it.
Yazid Ahmed so, become weekly body plan. But, option, significa, কথা, না উত্তর তিনি দ্বারা সম্মত প্রকাশ করা বিচারপতি ইমাম
Bainama is 6/6/2014. Are you sure?
6614. Well, Bapuram said Malot that he wanted to sell one katha, 1 bigha to 1 katha of his own or. So that is why he sold 2 bigha 1+6 meter to the petitioners later on. But here he has entered Malot the entire land.
Exhibit 5 is dated where? Where do I find it? Ah, 6/6/2014. Now here, what do they say? Anything about possession?
No.
Read it. That might be give you a clear indication.
কথা জমি বিক্ৰী কৰিব খোজাত আপোনাৰ উক্ত কিনি লোৱাৰ সম্বন্ধ প্ৰয়োগ কৰাত বিঘাই প্ৰতি 44,000 টকা হিচাপে মুঠ 1,56,640 টকা এক বন্দোবস্তি কৰি আজি আপোনাৰ পৰা বাইনামা নগদ 1,50,000 টকা ললো বাকী টকাখিনি আপুনি ৰেজিষ্ট্ৰি কৰি দিয়াৰ সময়ত মোক দিলে মই আপোনাক চাপ বিক্ৰী কৰি দখল সম্পাদন কৰি দিম দলিল সম্পাদন কৰি দিম মই যদি গাফিলতি আপুনি চাপ বিক্ৰী সম্পাদন কৰি নিদিলে তেনে আপুনি বাকী টকাখিনি আদালতত জমা দি আইনৰ সহায়ত চাপ বিক্ৰী
Now, Mr. Sharma, how do you take care of this situation? When the Bainama you are asking, you are saying that this is your document. Wherein it says, on one hand, you are saying that since 1994, you have been in possession. But the document on which you are relying upon shows that he is going to hand over the possession. How do you take care of that situation?
Actually, the land, Schedule 3 land, that was in possession, in my possession.
Actually, maybe, but I'm not on that. But if you are relying on a document which shows that there is that there would be, the possession would be handed after the deed of sale, and you have not stated in your pleadings that thereafter you entered into possession, then how can you prove your possession if you are relying on this document?
We are in possession before.
Before it's okay. You may have stated 1994 you have been in possession, but you are relying upon a document. I would have said that if this document was not there, it would have been a different aspect. But once this document is already there on record and on which you are relying, it says that the possession will be handed over to you. Thereafter, isn't it required that you to say that in spite of that I was in possession, I have entered into possession and I was there on that date? How do you take care of that situation?
The writing, generally the right, even if the person in possession, the writing of the deed is like this.
Huh?
After execution of the deed, I shall hand over the possession.
Yes, very well. But isn't it required that you have to plead that? There is no pleading to that effect.
Pleading-
Your pleading is From 1994, you have been in possession, rightly so. But there is nothing mentioned. You also mentioned about the deed of sale, agreement for sale. But you don't mention that I was all along in possession then also, that the deed of sale agreement was sale that I would have been handed over to me. That is, you do not say that to be wrong or anything to that effect. But on the other hand, to you rely upon this document and put it as Exhibit 5. Now, this document shows that the possession would be given out to you as on 6/6/2014, the possession would be given to you. It has been mentioned. Now, thereafter, there is no statement in your plane that you have entered into possession or you were thereafter also you were in possession.
But that sale deed was not executed with Bapuram.
Understood, it was not, but this is your document. Isn't it your admitted stand in view of
But
you
that-
relying upon this document?
That position is the legal position, the actual physical position we are here. And after registration received,
Then
we'll
where
get
is
the
the
legal position.
where is your explanation of the in your either evidence or even in your pleadings to that effect that there it was a the legal possession would be handed, the physical possession would be different. How do you take care of this? It's a different thing. Mr. Saiwala did not bring up this point. This is because that is the biggest point. Means when you draft the agreement, you never point out that thing. It is normally it is done.
Yes.
I understand this is done, but this is a legal flaw.
But even original position also, my lord, he must say how he came into position. That is Supreme Court says, my lord.
No, understood. No, he said that since 1994 the land was lying idle, I have entered into possession. He said that. He even given all this, but there is no mention that in spite of this, because if he had not relied upon this document, which was absolutely not necessary,
And moreover, my lord, the mutation of Bapuram, the auction purchase, then in my mutation, my lord, that also, my lord, shows that my position is there. Otherwise, I cannot get mutation, my lord.
I think we should remand it. The only way out is either remand it, then you may be able to give some evidence to that effect, explaining it. Or the thing is that I have to set aside that. Which one do you want?
Remand only point of this document.
Yes, only on this point. I'm not keeping this. No, you if you are allowed to give evidence, he gets the chance of evidence. That is the only way. Otherwise, I have to set aside. I'll take that as Mr. Sahewala's argument. Legal point. But remanding it, I think you can very well explain by filing additional pleadings that this loophole is there. So this loophole is whatever it is. But how do you take care of this? Because this document you have accepted. If I was taking just bench 1, I would not have remanded it. I would have finished it off. But taking into bench 5, being under the euphoria of 226. So therefore, I'm becoming more reasonable in this. So, Mr. Sharma, what do you want? Remand or set aside? Because I can't, the problem is there. The moment it is remanded, you may have to file additional pleadings to explain that. It's additional pleading, therefore I can't only limit it to a particular point. Because you can't adduce evidence without there being a pleading. You want to think about it? Give you time. Have it next week. There's a stay I've given, so that will continue. The stay I've given, so that will. Heard Mr. G. N. Sahiwala, the learned senior counsel, goodbye. As well as Mr. A.C. Sharma, the learned counsel, senior. As well, so. For the petitioner, during the course of the hearing, the G. N. Sahiwala, the learned counsel appearing on behalf of, senior counsel appearing on behalf of. Admitted that the impugned judgment suffers from perversity in as much as, on one hand, Exhibit 5 have been, as much as the learned court below failed to take note of that in Exhibit 5, which is a document adduced by the plaintiff, it has been categorically used by the plaintiff dated 6/2014. It has been categorically mentioned that the possession could be handed over to the plaintiff pursuant to the deed of sale being executed. He submitted that there is not a single shred of evidence, pleadings or evidence to that effect that after 2014, 6/6/2014, the plaintiff have entered into possession. And as such, if the plaintiff had not shown his initial entry pursuant to the execution of Exhibit 5, the entire the judgment so passed, impugned judgment so passed, suffers from perversity. Mr. A.C. Sharma, the learned counsel appearing on behalf of the respondent, submits that he would like to go into have a look at the records in that regard. This matter again on 17th of September 2024. The interim order passed earlier shall continue till then.
No? May please your lordship, my lord. On the last
Yeah.
occasion, my lord, I could not explain satisfactorily to your lordship, satisfactorily, my lord. The queries your lordship had raised, my lord. Now, first of all, I will draw your lordship because on that day, actually, these rules were not made able with me, my lord. That today I'm producing before your lordship, my lord, the medical benefit rules 1983, my lord.
May I those?
My lord.
I'm allowed to play the keyboard.
These are the rules, my lord, framed by the Board of Trustees, my lord. The Board of Trustees is the highest body of the Assam Tea Employees Provident Fund Organization, my lord. And just am I reading, my lord? The Board of Trustees, the Assam Tea Plantation Provident Fund and Pension Fund Scheme is pleased to make and adopt the following rules governing medical treatment of its employees and pensioners, namely. This is, my lord, this rules is in the nature of, my lord, guideline, my lord. It is not an statutory rules, my lord. It is a framed by the Board of Trustees, my lord. Now the next, my lord, I will draw your lordship attention to these Assam Medical Attendance Rules, 2008, my lord.
Why are these rules made by
My
the
lord.
Board of Trustees?
Board of Trustees, my lord.
Why are these rules made by the Board of Trustees?
For, my
Under
lord,
what power?
For the regulation.
Under what power? Power is from where?
From the
Power has to be derived from somewhere.
From the board, they have framed this, my lord, rules, my lord. That is
Power is from where?
at that time.
The board can frame rules on the basis of some power from
Yeah.
a statute. Where is the statute?
At that point, sorry, I will. This is my lord, this is Assam Tea Plantation Provident Fund and Pension Fund Scheme 1968, my lord.
Then,
These are
Yeah.
actually 1955 original.
show me.
Also the Assam medical rules.
1955. There, I think the power will be there somewhere.
My lord.
There's the rules. This is for Assam Tea Pension Fund and Linked Insurance Scheme 1955. Where's the power to make rules?
That act, I'm looking, my lord.
3.1. There's a power.
Compulsory Provident Fund.
My lord.
By notification of your frame a scheme to be called the Assam so and so Pension Fund Scheme for the establishment of provident fund so and so. The scheme shall be the contributions. No, where is the power to make the rules? Or it has to be prescribed, where is it? As regards the medical benefit. This is the
That
medical
I'm looking, my lord. I'm sorry, my lord. That.
unemployed
That for
medical
actually,
benefit. Under what provision?
This is scheme, my lord, at the page 14, my lord, the Assam Tea Plantation Provident Fund and Pension Fund Scheme 1968, my lord. The board, the definition of board is specially mentioned, my lord. The board means the board of trustees constituted under para 3 of the scheme, my lord.
Where is medical benefit?
Very good bill.
Your lordship may cover under rule 20, your lordship, at page 18 of this act.
18.
Yes, your lordship. 20B.
T.
20B.
The board shall, with the approval, make regulations regarding recruitment, pay and allowance, discipline, superannuation, and other conditions of service. So, this is with the approval of the government. Now, therefore, you may make the rules, the board. But did you take the approval for making this? Answer rises there. And the board make regulations regarding this. If this is the power which is being related to these rules.
Now, this, my lord, this medical rules, so that has been framed by the board, my lord, not by the government, my lord.
Understood, but can the board
Yeah.
frame without, with the power is where?
Well,
The power has to be on the basis of 20B.
well,
If 20B is there, it is subject to the approval of the government.
but that was enforced, my lord, that may be, my lord, yeah. You shall previous
Huh?
the medical treatment of the board.
What?
That's why I'm looking, my lord.
You have a look, consult with your people and find out the time for that. Because these rules, I think there will be a provision somewhere. How is the cost of medical attendance and treatment? And how it was changed?
Changed, but that was, my lord, in view of this, my lord,
Yeah,
that's for that actually,
29.
I'm drawing your lordship attention.
The
So,
members present, the
uh,
official memorandum, S.K. Lohia suggested that there should be a ceiling on medical reimbursement. Labor Commissioner referred to the government rules in this regard. After detailed discussion, the members decided to apply the rate under SIA for reimbursement expenses for board employees. This is it.
madam, there's some medical attendance rules, madam, I'm drawing your lordship attention to page, page 5, my lord.
Will be
Uh,
reimbursed. Yeah, we must. No, everything is understood. Kindly come to Annexure B of his petition,
My
page
lord.
30. There are medical bills of the board employees and pensioners would be reimbursed as per the rate declared in CGSS with effect from so and so.
My
Till
lord.
there it's okay.
My lord.
Why the remaining portion is there? The cost of the treatment beyond so and so has to be borne by so and so.
That is,
What
my
is-
lord, this is same thing.
Why-
is-
No,
as
no,
drawn from
this is
my
not
lord,
a,
that
this is,
uh,
Mr. Das, this is not a part of the resolution.
my lord.
This is the part of the resolution, the cost of the
But-
treatment beyond
But
CGSS.
that will be subsequently, my lord, annexure B to my affidavit opposition, my lord, page 30, my lord.
Page 30, that is what I'm saying.
My lord,
Page 29 is the extract,
my lord,
where only the decision is that the rate under CGSE for reimbursement of medical expenses for the board employees. That's all.
my lord.
Why did you add the remaining portion?
That is, my lord, in the light of this decision taken by the state government, my lord, that which you will lordship find at page 5 of the Assam medical attendance rules, my lord. In same light, well, in the by drawing this, my lord, this decision of the state government, my lord, the board of trustees also adopted this same resolution, my lord.
Eh,
Page 5, serial number 10C, my lord. The ceiling for reimbursement shall be in accordance with the latest rates prescribed under the state and central government health scheme. The government shall reimburse the cost of treatment at the empaneled referral hospital as per the CGHS rule rates only. The cost of treatment beyond the CGHS rates for hospitalization treatment shall have to be borne by the employee's pensioner family, my lord. These words. The excess amount shall have to be borne by the employee, the
But can the
Chancellor.
secretary,
my lord,
come PF commissioner of the board of trustees
my lord.
say anything which is not there in the resolution?
That part, my lord.
You are the expert on this.
Government matter. That was not yet approved by the government matter. Without approval of the approval of the government matter. There is no approval to that effect. And I would like to draw the page number 65 of the representation also, my lord.
Yes.
Board of Trustee, ATEPF organization in its meeting held so and so have decided to bring the newly appointed employees. I am not newly appointed employees, I am already retired person, my lord.
How does this have any relevance?
Okay. As per this notification, my lord, it is applicable.
You are people who retired prior to 2011.
There is two set of people, my lord. One retired prior to 2011. And
You are prior to 2011. So your basic thing is my services were already there. It's there. Now they are changing it after my retirement. That is what your case is.
and since
Now you are challenging the jurisdiction also to the effect that how are you doing it, taking into account that the regulation have not been amended
my lord,
by
notification,
way of a notification or no, this is by way of a notification. Shall upon make regulation regarding, there is no notification required. 20B does not require, shall make a regulation, but with the approval of the government, without there being an approval.
since this benefit was provided to the persons, my lord, 1955, my lord, and rules came into 1983, my lord. Prior to that benefits were also provided. And during my entire service period, my lord, I have contributed PF fund. It is compulsory. And there are two set of employees, my lord. One set, all are not eligible for the provident fund. Not become provident fund members, my lord. The person who are doing salary or wages in
Mr. NNB Chaudhary, there is one matter, I know, come here. I know you are a very busy counsel. There is one matter where I am going to appoint you as an amicus curiae. This is a case where there was a police officer, there was a person suffering from schizophrenia. This person, at the time of his bail also, made it very clear to the judicial magistrate that look here, this person is suffering from schizophrenia, kindly give him break. The judicial magistrate did not grant him the bail, but specifically stated that a special, he shall be taken special care of. Now what happened, he was put in another place along with other inmates. Now this very person, what his name is Farooq Khan or something, he with a brick killed one of the inmates. Now the question here, he has come, the wife has come before this court asking for a compensation on constitutional tort. Now the counsel appearing from the petitioner had hotel, he does not know anything about the jail manual and all and what is to be required. So therefore, I am appointing you as an amicus curiae. Hey, order to come to assemble item. Item 2. So and so Mr. NNB Chaudhary, the learned counsel. This court, during the course of the hearing, I had requested Mr. NNB Chaudhary, the learned counsel, as to whether he would agree to be an amicus in the instant matter. He submitted that he would be ready to assist this court in this regard. Accordingly, Mr. NNB Chaudhary is hereby as an amicus curiae to assist this court. His name may be shown in the court list. The registry shall give him a set of papers, a copy of the petition along affidavit within 7 days from today. Let's find out what is to be done, because we may have to, if there is nothing in the jail manual, we may have to develop the law so that something has to be done. Because here they say that we don't have any other room. That cannot be a thing for keeping somebody who is suffering from mental disorder. And they did not carry out those tests at that point of time, which was asked.
Yes, ma'am. I shall take help from the one NGO studio Nilima, ma'am. I shall take help from them.
Whatever may be, I'm asking you to be an amicus and it will be on, it's fixed on 19th. So they gave me some magistral inquiry report, but that report is not so good. So I've asked them to put every other document, but I think something needs to be done as to, because this is a case of a jail aspect as to how it is there.
All the documents shall be sent to me.
Lord, I'm pointing out, my lord, this is the first time they said this point, my lord. Now my learned friend is urging, my lord. That was never by urged before the earlier to petition, my lord. For the first time that this petition is now is urging before your lordship, my lord. And
Regarding-
for that matter, I am
No,
just
the fact
drawing your
that-
lordship attention to annexure 6 page 102 of my affidavit in opposition, my lord.
100?
102, my lord. This is the office order passed by the Secretary cum PF Commissioner, my lord.
No, this shows that you have accepted in view of the government of Assam accepting it.
My lord, my lord.
So now the government of Assam has stated this aspect in its medical rules
My lord.
of 2008. But whatever the earlier, these medical rules apply to all employees of regular establishment while they are on duty or leave or on. Now, and what was the status at that point of time to the Assam Medical Attendance Rules 1976?
That I am not, I have not gone to the.
No, you see, these rules of 2008 had superseded the 76 rules.
My lord, correct, my lord.
Now, if that be so, there must have been something to that effect. Because this happened in 76, you came up in 83.
My lord. That's one thing, my lord, just I am drawing your lordship attention. In
These are all 309 rules.
my lord.
But anywhere in your act or the scheme, is there any mention that apart from all these things, you will follow what is there by the government of Assam, or you are bound to follow?
Or that part actually I have not checked up, my lord. No, but above, my lord, actually, can I draw your lordship attention to page 110, my lord, of my affidavit, my lord? This is the finding given by a coordinated bench of this honorable court, my lord. In the second petition, my lord. Page 110, my lord, it is further provided that in the event such pending medical bills are prior to 22/7/2011, when the decision of the Board of Trustees was taken, such bill will be governed as per Rule 11 of the 1983 rules, and the subsequent bills would be governed by the provisions of the rates under CGHS, my lord. This is the finding of the final decision given by a coordinated bench, my lord, in the second petition, my lord. This and as
No,
against
Mr.
this, my lord,
Das. No, Mr. Das, see the next paragraph.
my lord. No, my lord, this
It
finding
also
about
provided that if the petitioners are further aggrieved regarding the rate of medical reimbursement to be made applicable for them in respect of the medical bill subsequent to so and so,
my
an
lord.
appropriate representation may be filed before the authorities and the authorities would give due consideration to the same.
My lord.
Now here, therefore, the thing which was concluded in the earlier paragraph was
My lord.
again brought in by the new paragraph.
Now, only my lord, my submission before lordship, this finding, my lord, as against this by finding given by the court bench, my lord, they are not any
Understood,
appeal.
but then also the next paragraph reopens the issue again.
My lord.
In fact, the last time also you said, I made it, I clear stated that this is only in respect to those pending bills,
Right.
how it is to be settled.
My lord.
But what about like his case is that look here, from 2011 I am there. I retired in prior to 2011 when this scheme had come into the amendment which was made. So I
Right.
should be given. And it is difficult to accept that submission. They can, the government can very well, there cannot be a vested right to that effect. But what is the most pertinent thing is how can you do it if you are making a regulation with the approval of the government?
My
You
lord.
can only remove with the approval of the government. Show me on what basis you say that you have a vested right on the terms, service conditions of yours.
My lord,
My lord.
entire service period, they are following the 83 rules, my lord. At the time of entering service and, my lord,
Understood. But can you show me something to the effect that the service conditions cannot be changed at any point of time? Once
lord.
you have entered into the
My lord,
service, the service conditions can always remain, that the government does not have the power.
20B, my lord.
Because there are many cases, Mr. Counsel, there are many cases of the Supreme Court to that effect, that a person may have entered the service thinking that his days of retirement is 50, 60. But the government still has the power to reduce it to 58. Because there was a saying that when I entered, it was 50, 60. So these service conditions to that effect can be very well changed. If
Okay.
that be so, why not here?
Lordship, 20B, my lord, page number 18, my lord, 68 rules, my lord. The board shall, with the approval of the government, make regulation regarding recruitment, pay and allowance, discipline, superannuation benefits, and other conditions of service of the members of the staff. There must be approval. Let's come to the, my lord, chapter to page number 19, my lord. My lord, first of all, I am neither the employee of state government nor the employee of central government, my lord. I'm the employee of tea owners, my lord, tea gardeners and tea factory owners, my lord. We are the, I come to the provision 22, my lord. Employee is required to join in the fund, my lord. Every employee is defined in Assam Tea Plantation Provident Fund Scheme Amendment Act 1955, my lord. Other than those who opted out for existing fund scheme, is laid down in section 3 of the said act, shall be required to join in the fund and become the members of, therefore, immediately after commencement of this act. Next, B, my lord, the board may allow withdrawal membership in respect of those members whose total wages exceed 6,500 per pension, my lord. The person who are doing more than 6,500, they are not eligible for that members, my lord. We are the low paid employee, my lord. We are a low paid employee, my lord. And next come, my lord. See, my lord, 23, my, see, employee who will be employed in the plantation or after commencement of this act shall compulsorily retire or join in, 23, my lord. The contribution which shall be paid by the employer to the fund. Employers means tea plantation owner, either or factory owners, my lord. Funds shall be 12% of the total wages payable each member of the fund, and such member shall contribute an equal amount to the employee's contribution in respect of him, my lord. Employer, some amount employer contribute, some employee, my lord. And
No,
that was
Mr.
taken.
Mr. Counsel, I understand this. But the question which I am putting you to is that can they not change your service conditions? Just for example, they make a regulation as per anything. Forget about India, because here it cannot be even limited to 2011.
My lord, I have
You have
retired.
retired 2011 is a
2011.
different thing, but if on the basis of your first submission, I take that you have been working for all this while. At the time when you entered the fund, the 83 rules was holding the field. And in 2011 only they changed. So all the people who have been there till 2011 or employed prior to the 2011 decision would be entitled to, irrespective of when they retire. That is not immaterial. You say that you have retired in 2011, it's okay.
Right to
But it will all apply for everybody. But can it be a proposition of law that the government or the board of trustees cannot change the service conditions, even with the approval of the board? Can you say it to be a proposition of law?
But so far as retired person who is prior to 2011, my lord, they are eligible for the 83 rules, my lord. Those who retired 2011, my lord.
No, why retired? Retirement is immaterial. It is not the question of retirement. It is the question of you giving your fund contribution
Continuation.
prior to 2011. That is the basis, irrespective of when you retire. Your retirement is not the question.
My lord.
Whenever you are there, you have, if you were appointed prior to 2011 and you have submitted or subscribed to the fund, you are entitled to. Now later on, they are trying to change. Now the question, therefore, I am putting it to you, can it be said to be a proposition of law? That the terms and conditions of a service cannot be changed. Because the Supreme Court, as I told you, as regards the age, Supreme Court says that the age can be very well changed. It was at that point of time, it was made from 60 or something, it was made to 58, 1962, 64 judgment. It can be said, it has been stated that the age can very well be lessened. It depends upon the government. So if the term to that age can be changed, why not this term? Unless you show that there is a vested right in regard. The other aspect is another thing as regards the approval. That is the next aspect. That without the approval, you cannot change. Because if it comes on the 20B, if they have not taken the approval of the government, they cannot do so. Maybe the government has come up with whatever scheme. That is a different thing, but you are neither a government employee or a central government employee. Yes, Mr. Das,
My lord,
is
just
there any vested right?
my lord, in view of this, the rider given in the second judgment, my lord, passed by this honorable court in WPC number 6512 of 2015, my lord, they have submitted a representation, my lord, that you lordship will find at page 111, my lord.
Mr. Das, I've
Well.
already rejected that contention. I
Well.
will note down that your submission, I'll reject that. Don't worry with that. Now
Well.
come to the second point. If you say that that is your only defense, then can the service conditions of an employee who is subscribed be changed by making an amendment? That's the issue. Can you change it? And that too without the approval of the government. Because if you have to make it, you have the approval, means when you remove it, you also have to have the approval.
One more thing, my lord. I would like to, page number 65 again, my lord. This petition, my lord.
60.
First paragraph, the board of trustees of so and so organization is meeting and held so and so, my lord, decided to bring the newly appointed employees, my lord. All right, my lord. Within the ambit of board's medical rules, my lord. Board's medical rules means which rules, my lord? There is no clear board's medical rules, my lord. They are talking about the board's medical rules. Means they have 1983 rules. They have not saying anywhere they adopted the Assam government medical rules, my lord. Here also, my lord. Means there, but that board medical rules 83.
No, they are not. They all till date also they don't say that they have adopted the Assam government medical rules. No, they are not.
Yes.
Their basic cases, look here, at that point of time, in 2008, the government of Assam has come up with a thing that CGSE rules are there. They are going to
trying to
adopt.
impose
So we are also have taken a similar stand.
Right.
That's all. So it is immediate that they, as their basic question is, therefore my specific question to you is, can the service condition be changed or not? Answer it.
My lord, even though when after retirement, that condition may not be.
When no retirement, retirement doesn't. You see, you are entitled to a particular amount when you are in service. When you retire also, you are and maybe entitled to a lesser amount. Now, when you were in service, at that point of time, you were supposed to get 70% of your income when you are retired. I'll give you an example. Later on, they come up during the time of your employment and say, then no, now we are having a financial crunch, we are going to give you 50%. Now, can that be done?
That is during the employment, my lord, there is other set of employees, my lord. During that course of employment, they may change to some extent, my lord, but after retirement, my lord.
Okay, you are not understanding. Let me deliver the judgment. You can't satisfy me on that. Deliver the judgment that you couldn't prove it, that nothing good has been shown. You are entitled to. And on the other one, without medical thing, you cannot do so. You have not taken the approval of the government.
Well, that facts of absolute are correct by your lordship, my lord. There is no any supporting documents, my lord. They could not produce any supporting documents, my lord. But this, my lord, only this was actually this medical.
I understand your point. I
Yeah.
understand your point. But the thing is, therefore, those people who have been in employment till 2011,
Well,
because after 2011, the position changed.
well,
So those who were appointed prior to that date could be involved by that. But then also, as of now, everybody will come in because till date you don't have the government approval. If I hold that without government approval you cannot, as of now also you don't have.
my lord.
It will have a catastrophic effect on you because only few petitioners have come. Everybody will
Yeah.
come. There will be a lot of claims.
That is a pensioners association. They have approached this. They have approached my lord. Pensioner, not only the other retired persons. Pensioners association.
Therefore, I am saying the moment I say that without approval of the government, you could not have changed, tomorrow everybody will come,
Well,
wouldn't they?
my lord,
Everybody will come there. Then how do you tackle that problem? Unless you show that the permission which is required or the approval is only required for initial making, for amendment not required. Or just for example, the power is with you.
Hmm.
And the approval or AI is only recommendatory, which is not required. Something has to be done. Otherwise, you as of there also everybody will come.
Can I pray for one next time, my lord, sir? Let me inquire, my lord, whether this, the original rule that was, the approval was obtained, my lord.
That is may also be very relevant.
My lord.
Then his entire rules goes.
Well,
He won't get anything. From tomorrow onwards, don't give him anything. Because there is no rules. But you have to satisfy me on that.
well,
What is your yeah to challenge it? Cannot service condition be changed? Well, there are judgments on age. I know that. Age can be very well changed. Age is also a service condition. It's a different thing. The government, in many cases, they don't want to go into that aspect and normally gives it. There are many cases where the government says, okay, till this period, I give it.
actually, but can I pray for at least a
Yes,
minimum?
there is one type of judgments
Well,
which happened, which I was dealing with at the time of in my judgment in this. I've mentioned those judgments. These were pertaining to old pension, new pension schemes.
well,
So there were submissions to the effect that we were initially appointed at that point of time when we were appointed, the old pension was holding the field.
well,
And as such, now the new pension coming in would not affect us. You may get some line of judgments on that, many judgments. That is
that I know.
a case in some Purnima Hore. I think it's reported in 2023 for SS, for GLT or something. Or in the July edition of July or August edition of 2024 GLR. Because there are many judgments to the effect where the division bench has also given to the effect that these were certain central government employees where at the time of advertisement the old pension rules were holding the field. But there was a delay in their appointment, and thereupon they were brought within the ambit of the new pension. They challenged
pension.
it. They said, no,
Well.
nothing doing. Because at the time of advertisement, what was holding the field? If that be so, that when you were working, if that was holding the field, then you cannot later on change it. I think similar analogy can appear. But there are other judgments also to that effect in that. But there is a division bench judgment which I am referring to of Justice Dhulia and I think Brother Sumitra Saikia. When do you want it?
Yeah, let it be managed after 10 days because all the officials are now there busy with the holding of this assembly, my lord. So they were supposed to come yesterday, but they could not come, my lord. Let it be after 10 days, my lord.
It's this matter again on 24th of September 2024.
24.
Heard Mr. So-and-so, the learned counsel appearing on behalf of the petitioner. And Mr. N.C. Das, the learned counsel assisted by Mr. A. Das, appearing on behalf of the respondent authorities. During the course of the hearing, this court raised two questions before the parties. One, whether the whether it is permissible on the part of the board to change the service conditions of an employee during the period the employee is in service or even post his retirement, thereby affecting his entitlement. Number two, whether number two, in view of the mandate, in view of 20 of the Assam Tea Plantation Provident Fund and Pension Scheme Fund Scheme 1968, 20B, stipulating that the board shall, with the approval of the government, make regulations regarding recruitment, pay and allowance, discipline, superannuation benefits and other conditions of service of the members of the staff. Can the board unilaterally, without the approval of the government, change those regulations which were made with the approval of the government? List the matter on 24/9/2024 for further.
25.
Huh?
Instead of 24, my lord, can it be 25 or 23, my lord, date, my lord? Then can it be 25?
26,
25, my lord,
26.
little bit problem, my lord. I have some
Obliged to your
person-
lordship.
25.
24 or 26? You have problem? Okay. Release from part heard. We listed before. Okay.
Can it be fixed, my lord? As you lordship, my lord.
Obliged to your lordship.
Anything else?
Yes, against the law point, your lordship, for which I'll just reply to that law point.
Only that. Tell me.
As far as the right of the register under 45 and the jurisdiction under Rule 27, submission advanced was that the AGM having been disapproved, consequently, the election to the board of directors go. On that point, if lordship would have to look for a moment. There is no quarrel to the proposition that it was an election to the board of directors as also an AGM. I admit to that extent. There were 4 to 5 agendas in the notice and an election agenda was also there. Page section 30 for a moment.
Yes.
Matters to be dealt in the AGM. The following matters, in addition to others, are considered necessary by the board shall be dealt with by the AGM meeting, namely 1, election of delegates and representatives if fallen due. Well, lordship, there has been an amendment to it prior. At the footnote, lordship gets the amendment. It was substituted on 5th of February 2013. Prior to substitution, it was election of directors or delegates if fallen due. Meaning thereby, the AGM notice referring to an election is independent of the other agendas. By a same notice, what was notified is audit, etc. of the earlier years as also an election notice. This election notice cannot be a part of the AGM notice. Therefore, disjunctively, if we apply it, even if they are disapproving it, they cannot touch upon the election because the AGM could not have notified election of board of directors. This leads to the next question. How then does the election of board of directors take place? It comes to 41 for a woman. Elections. If I may read it. The superintendent's direction, control of the preparation of electoral rolls for and the conduct of all election to a cooperative society shall vest in the registrar. It shall be the duty of the registrar to prepare the voters list with eligible members to arrange for holding election of directors, delegates, or representatives to the delegate general body and representative of the society if fallen vacant. The election of directors to a board shall be conducted before the expiry of the term of the board so as to ensure that newly elected members of the board assume office immediately on the expiry of the office of the members of the outgoing board. We skip the rest for a moment, Milord. It deals out a procedure. What I am on is the problem all along.
Now kindly come to number 5.
Number 5. The election of board of directors and delegates shall take place at a general meeting called for the purpose. Absolutely. In a general meeting, delegates are persons who represent group of members as per the definition given in section 2, Milord, MNO, 2O. And by operation of the board, the AGM cannot call for election of directors. Directors would be different from the election of delegates. And AGM can be only convened for election of delegates or representatives. The concept of representatives would come in when there is a secondary cooperative society, when a society is a member of the society, parent society, primary and secondary society.
32.
Absolutely.
Section 32.
My lord. In case of secondary cooperative society, the concept of representatives would come in. In other case, delegates might come in. So whenever AGM is held, in that AGM, there can be an agenda for election of delegate or representative. After 2013 amendment, it has been taken out from the scope and jurisdiction of the board to call for an AGM wherein the election can be an agenda, the directors. Therefore, although I submit with all humility, my lord, although the notice notifies agenda for AGM, it also notifies agenda for election. This election takes away from the purview of 45 the jurisdiction of the registrar, if any at all, to touch upon the election. Because election would, by the notification of the notice, embarks upon a journey from Rule 27 of the rules, which came in 2019. That is how I would like to address the lordship.
It say section 32
Fine.
in relation to a general meeting,
Fine.
which can be called at any point of time. The members of the cooperative society, which is different from an AGM, which is to be called a general meeting to be termed as AGM of the registered cooperative society shall be held at least once in every cooperative year within a period of 6 months of the close of the financial year to transact the business as provided in the Act. So you mean to say, therefore, an AGM is different from a general meeting? A general meeting may be also an AGM, but an AGM is different, but for the purpose of, it is only the AGM which can be approved.
Absolutely.
The question of approval of a general meeting does not arise.
Doesn't it? Second, the test of rule section 39. If a body fails to hold a meeting within 1st of April to 30th of September, the board of directors is dissolved by operation of law. The delegates and the representatives so elected are not affected. That's the language of section 39.
Now kindly come to 45.
40. Minutes of proceedings of meetings. May I read, my lord? Every cooperative society shall record in the minutes books in the official language of its station or in English or in any other language prescribed in the bylaws proceedings of every general meeting, delegate general body meeting, and board meeting, and the names of the members or delegates present thereat shall be confirmed at the same or next meeting. The proceedings of all general meetings and special general meeting of every cooperative society complete in all respects as provided in the Act and bylaws shall be sent to the registrar within 15 days from the date of completion of such meeting with due acknowledgement. The registrar shall give his approval on the resolutions within 15 days of receipt of the proceedings. If no approval is received within the aforesaid period, the
So a
proceedings
general meeting also.
absolutely required.
No. But if you see section, this section at section, right, section 30, no, where is that? Election, 41. 41.5 say that the election of a directors and delegates shall take place at a general meeting called for a purpose. Now, these general meeting minutes have to be approved.
I'll take it this way. Election is not approved under any law. The results are declared.
But the general meeting has to be
I-
approved.
I come to that, no. A general meeting can be held by the authorities in power under section 32. It only takes this name of annual general meeting. for
We are
the
not concerned with the AGM. Forget about the AGM. Let us assume that this is a general meeting, may have the other effects of an AGM, that I'm not concerned, but it is a general meeting. But AGM is also a general meeting.
in case of a general meeting which does not have election,
Or should we hold that there is no general meeting at all?
there's no general meeting at all for a purpose. So
Then
far as
without a general meeting, there cannot be an election.
election can be done by the registrar because it reads on the registrar or is one man who's there. They proceed on to hold the election. The result has to be declared. Whether by the
But
voters,
where? The elections are to be held in a general meeting.
I get your point.
And
May I-
this general meeting has to be approved.
I'll come to that. If elections are held, the powers of the registrar to approve or disapprove gets intersected by Rule 27 from the date of election notifying of the elections program. I'm coming to that once again. I'm trying to make myself clear.
In
If-
that submission, if you make, then Rule 27 would be ultra virus rule section 45.
Section 45, if I read once again, I'll read once again.
Section 45, you have to read with section 41.5.
Also, 47 also requires specifically the registrar, not any other person. May I read 47 also for a moment? Unless contrary is proved, every meeting of the general body or the board shall be deemed to have been duly convened and held, and all members of the meeting shall be deemed to have been duly qualified when the minutes of the meetings have been signed in accordance with the provisions of this act. However, the proceedings of the AGM and all general meetings shall require approval of the registrar as provided under section 45. Now, why I am on the word approval? Approval of the registrar in this case, in case of elections, when convened, the elections are by a board or by a one man. When it's by a board or by a one man, there can be conflicts in opinion of members, shareholders, that the voter list is not drawn up. That the voter list is not drawn up properly. There has to be, and because elections have not been notified till now, but elections would be held. At that case, I'm submitting for the time gap. Rule 26.3 comes in. It brings in some time restraint conditions. May I read 26.3 for a moment? 26.3 would bring in its suite. The chief executive of every cooperative society within 20 days of closure of the previous cooperative year shall prepare a list of members with the right of vote and a list of members without the right of vote, valid for the current financial year. The list shall be affixed on the notice board of the head office of the
Rule
cooperative society.
20?
6(3). We have prior to elections being notified now.
This
The
is
chief
expenses of election 26.
26(3) section. This has a bearing because it is prior to elections being notified now. The chief executive of every cooperative society within 20 days of closure of the previous cooperative year shall prepare a list of members with the right of vote and a list of members without the right of vote, valid for the current financial year. The list shall be affixed on the notice board of the head office of the cooperative society for information of all members, and any member not satisfied with specific instances of inclusion or non-inclusion of members in the lists may appeal to the board within 10 days from the date of affixing of the lists on the notice board for re-examination of the records, and the board shall, within 40 days of closure of the previous year, review the list, finalize it, and have it fixed on the notice board of the head office of the cooperative year. So, prior to election, all disputes concerning voter list inclusion or non-inclusion, there's a time frame given, and the authorities indicated where to put, who to decide, what to do. Now, here you have to appeal to the board within 10 days. In case there is no vote, the one man is functioning. Any order passed therein within the time frame, there is no deeming provision below, would be tested under 111. The registrar would exercise jurisdiction under 111 so far as voter list is concerned. The registrar exercises power under 45 to approve or disapprove. The registrar,
And there was one which was filed on 14/8.
my lordship,
14/8
an objection was filed.
filed.
That objection was filed after notification of the election program.
To what?
I'm on that. my lord. If after election notification of the election program an objection is filed, and if my lord for a moment takes it to be an objection under section 26(3), then the registrar had no jurisdiction to address it. It was the board or the one man who would decide, if at all. It ought to have been filed prior in point of time. But since it was filed after the election dates were notified, therefore registrar had no jurisdiction at all to touch it. It was only under Rule 27. Therefore, if we go by the impugned order for a moment, what the registrar actually discussed? The registrar discussed the voter list. The registrar discussed in accordance with the voter list, I am not giving approval to the AGM. If there is any other AGM, apart from that which is notified, because what is under notice is an AGM with 4 agendas or 5 agendas and an election. The jurisdictional registrar did not touch upon the election. Rightly so, because he knew that they cannot, because under Rule 47 there is a bar. There had to be a challenge to the nomination, there had to be a challenge to the declaration of result, there had to be a challenge to the participation, all within 3 days of declaration of the results. Results were declared on 18/3 and the observer says so on record. There is no challenge to that.
Section 45 does not say about AGM.
On my lord is section
Section 45 says about a general meeting or a special meeting.
meeting or a special meeting is exclusive then of an election. The
No,
registrar.
Absolutely no. It is a different thing. Just for example, they have coincided the AGM along with the general meeting. Maybe.
Elections were never touched by the
Then there
registrar,
is no general meeting at all.
but this would have a, I mean,
No,
Why the-
then we are to hold it that there is no general, if we are to take your submission, then there is no general meeting for the AGM, for the elections.
elections are concerned, these are notified, but the authorities would come into it. And once the lists are drawn, what I am on is that if you decide on the 26(3) is prior to the elections. If you say the lists are wrong, the voter list is essentially wrong, as is held by the order impugned, then it is a decision under 26(3), which ought to have come prior to notification of the election. After notification of election, this power is not left with the registrar to touch upon. And that too, the limitation time of the 15 days. Election was held on 18/3 and the impugned on the 3rd of April. It's on the 16th today. In otherwise also he had no time to touch upon it.
Right?
If it's 18th of March, 19, 20, 21st, 22nd.
No.
from receipt,
No, from the date of receipt. When was it received?
84, 82,
From the
80
date of receipt.
82.
Where?
Page 82 of the petition.
When was it received?
18/3, it was given to Assistant Registrar.
How do you know?
From the date itself, 18/3,
No, there is somebody has written, you have signed it. Where's the date of receipt?
that my colleague can produce. On
No,
the date of
you are-
election, the
you-
observer gives it to
No,
registrar.
no,
because
you have to.
Received by officer is also received by registrar. He does not have to travel to Guwahati, Milord.
No, when did you receive? Send it within
So this
15
is
days. You are
observer.
supposed to
This is
send
the
it.
observer sending it, Milord. It's the official transaction between them, intra-office. That this is what I had done, this is what it held, and we have declared and we have given it to you, the observation report of the AGM. I just placed my submissions on both sides, right? And based on the legal issue, how things moved on. Because I said registrar has no jurisdiction under 45 at all. Once the elections come in.
But then also there is a requirement of approval of the general meeting.
Here the registrar is silent on that, 102, page 100, page 84. 84 for a moment,
No, he has categorically said.
84 is the first order.
Yes.
84 is the first order, 3rd of April 23.
Therefore, it can be
Last.
certain that the voters list of so and so was held on had been in violation of so and so and is liable to be disapproved and is therefore is to take action accordingly. So it has been disapproved.
Disapproval of the voter list.
No, disapproval of the election.
Disapproval is not of the election bill of the
And it's a
AGM.
violation and is
Of
liable.
AGM.
No, no, and no, disapproval of the
Hence-
AGM.
If I read, hence AGM of Meherpur so and so
Let us
held
not
on
go
so and
by
so
the,
have been violation.
the
AGM is not
the
GM.
finesse of these words. Let us not
AGM
go by the.
does not give the right of the directors.
Monique, let us not go. We understand that you have the finesse of the words, but the register may not.
I leave it
So
to you.
after all, it's an officer. Let's not go by that. But the fact is, on 3rd of April, it was rejected, disapproved.
Why-
And when it is disapproved under 45, when it is well settled, when a provision has been invoked for a particular purpose, and that provision has been invoked only for the general meeting out there, it has to be understood when 45 is used, it means that it has disapproved the general meeting, whether they use the words in that better words which they could have. Yes, it may not be so satisfactory, the language, but then also they have invoked 45, not to disapproved.
But
Anyways,
anyway, I leave it to you.
anyways,
But other-
submission was nice at the first.
But the other side of it, Milord, if I may place it, the other side of it. Elections, if the interplay between section 45 and rule 27. If elections of board of directors are to be approved, then the declaration of result has no meaning and the 27 becomes OTOs. 27 is brought in with the legislative intent after the judgment. That 27 is the way and 27 is the time period when the jurisdiction is to be exercised.
No,
The
no.
constitution touch upon the election does not.
No, no, first of all, let us see the judgment.
Touch.
Does the judgment deal with 45? No,
Perhaps there's a copy of the.
that judgment does not deal with 45. It deals with
Registrar's
111. The question of approval is not a question before the score.
No, it's not, to be fair.
19.4. As per section 45, the general meeting of cooperative shall be sent to the register within 15, who shall thereafter give his approval on the AR within 15 days. If no approval is received, then it shall be deemed. 10. With regard to the AR of the income, wherein the entire responsible for preparation of electoral dispute arising out of an election. Look at section 2.
There's another interplay which is relevant to interplays. General meetings and general meetings having elections will be different in terms of 41, the judgment by the Supreme Court, because 41 says the superintendent's direction and control of the preparation of electoral rolls for and conduct of all elections to a cooperative society shall rest in the registrar. It shall be the duty of the registrar to prepare the voter list with the eligible members to arrange for holding of election of directors if I come. So when it's the registrar who is drawing the list of voters, in terms of the judgment, the registrar cannot sit over and appeal over the same act he has done. Therefore, the power is given to the board under 26.3. Therefore, the power is given to the board under 26.3 to decide the correctness of the voter list and meet the objections. And therefore, the judgment comes in to say that there must be a separate authority who would deal the election disputes. But unfortunately, the rules come in 19 and they give the power to the registrar, which is unchallenged. Now the registrar exercises power to see the correctness of the same voter list, which he has prepared under Rule 27. Therefore, 45 did not come in because 45 cuts to 41 because his own action, he cannot sit in appeal. So therefore, a general meeting, maybe any other meeting, but the moment it's an election, his power is vested in Rule 27. Although,
But Mr. Mohan, if you challenge for problem continue to be there because the approval has to be given by the registrar. The registrar, if a power is vested upon an authority to give an approval, it shall also be deemed that he has the right to give.
Lordship, we invoke the doctrine of cases omissus, These are things which if challenged, it has to go to division bench. But in a amidst the proceedings, when legal points pop up and arguments are made both ways, addressing on the law, interpreting both ways, and then lordship is to construe. The only construction left is either in this favor or in the other favor. But regardless of the facts of the case, regardless of time frame, when the registrar draws up the voter list, he cannot sit in appeal over them in exercise of 45. But in other general meetings, they requires an approval. Here is a case when he is drawing up the voter list, and this issue, this aspect of the power of the registrar was taken up by this honorable court in that judgment, which then directed that no, there should be a tribunal. As the High Court is a tribunal for other matters, or Panchayat Act is a tribunal, there must be a separate tribunal and rules must be framed. And therefore, the power was given to the session judge or district judge to take it. Thereafter, the rules came but vested the power of the registrar. So the registrar power under 45 is curtailed. Cannot sit in judgment over his own action.
Correct, if I may say, the power given under 41(3) is only as regards procedure and manner of the elections.
Absolutely.
So therefore, you have the election laws, you have the conduct of election rules,
Obliged.
61. And the power which is given to challenge an election to have been in the act itself. It could not have been brought within the ambit of a rule-making power only which is there for conducting the procedure of the election. The 27 otherwise should not have been there, should have been somewhere in the act.
Correct. I
Therefore,
think
you see the representation of People's
Correct.
Act, it contains the particular manner how you select. But 27 should not have been a part of this.
and 27 should not have vested but you will pardon me for that, should not have vested jurisdiction on the registrar. It should have the independent tribunal. Because a registrar, if goes by the judgment of the honorable court in complex with 329 of the constitution, whatever powers exercise, cannot be vested with a jurisdiction to decide his own action. Superintendents control everything by the registrar, or in the other case, election by another man. That authority cannot decide the correctness or otherwise of the election, or the voter is drawn. Therefore, the
No,
necessity
the
came in.
judgment says so.
Says so.
The judgment draws the analogy from the representation of People's Act, the Constitution, everywhere. Because the power which have been given by the Act is power given by a statute to the High under the representation of People's Act. In many other statutes, you find the elections which are being challenged out there, the district judge
Panchayat,
has been given to the. But when it is the case otherwise, here, challenge could not have been made under, or that provision of challenge to the election could not have been under 27 in that thing. In fact, the challenge should have been in view of 45 itself.
Absolutely.
It was not required to put 27.
But an authority, 45 comes, in- if an embargo comes in, because under 45 and the 41, gentleman is the officer concerned, the registrar here, is the one who is in charge of everything. So the voter list, if is the agony, that is 41. He does it. If the process of the election is under challenge,
Because
then
he,
27.
no, because he has the overall superintendence of all cooperative
that
societies.
is his judgment
That
said.
is why it has been mentioned. No, therefore,
He
you
says the
see,
registrar cannot exercise jurisdiction.
under 111 it has been
Say.
stated out there that it cannot be done, it should have been done by way of a rules. But while doing so, the rule-making power is only for conducting. It's 41(3). If the rule-making power is only for conducting, how the position of challenging an election be brought within the rules?
This thing was never challenged or taken up suo moto for any reason whatsoever. But I would still hold it that the registrar could not have been given the power under 27, although it is the law. Although it is the law.
Okay, the 27, that is the law, it is in fact couldn't have been, because the power is only under 41(3).
41(3). That's what.
Read 41(3), that is the
Take
subject
it
to
to
the
the
provisions of the constitution and provision, the state government may make rules to provide for the procedure and guidelines for conduct of the election. If that be so, it could not have transgressed and given that power under 27 there.
And the rules have come under.
We will
also
expect
51.
someday a challenge from Mr. Bonik about that.
The wise man is smiling. Still acting.
Requested him to challenge it in some other cases.
Now, in one matter, missing autonomous council case, I just kept one thing, because that judgment when I delivered, see, most of the fishing cases, fishery cases are all the problems is being caused by the missing autonomous council. And the cases of extension is also because of missing autonomous council. At the end of the day, when I said the missing autonomous council has nothing to do, but then also I kept one rider out there, that missing autonomous council can then also challenge that particular or notification. I kept it, the observation shall not. So that one fine day, he may challenge on behalf of.
The may I read paragraph 25 of the High Court's order.
Which one?
No,
I've seen it. I understood the basis why it has been done. Okay, very well. He said that it could not have been, the analogy which has been drawn out there is to the effect that, but the court does not touch 45 for that. You see, if you now take into account 41(5), 41(5 that the general meeting, in a general meeting, the election of the directors have to be held. General meeting has been defined in 32. 39 is AGM. AGM is also one of the AGM.
may go against me, but it's a possible view. There was no general meeting.
That is what I'm saying.
Fair.
Yeah, therefore I'm saying. No, I therefore said to you, if you hold that this is only an AGM and not a general meeting, then there was no election at all.
Lot of things will remain untouched. I'm on that.
Yeah. So there again the problem arises. But at the end of the day, the problem is, let us hold it, whatever maybe they have now given, because there might be a case of not holding the AGM within a particular period, which may lead to a lot of disqualifications.
Count Lordship may also examine if Lordship is taking that view of the matter, which is also following. That registrar exercise his power beyond 15 days.
Done. Unless you show that it was received earlier.
He did that 18.3, they are not disputing that. There's not a shred of.
No, no,
they have-
you say that 18(3) was given,
Yes, yes.
but when it was received, no, no,
They are
it-
not, they are not disputing that. my lord.
page 82 is a communication of 18(3). There is no receipt on 18C.
They say that they are within time to do it. That was submission on last time, if I recall correctly. They have to put it on record, at least they have.
My learned friend, my submission was, what I said, page 84, it is very clear that before expiry of the 15 days, the registrar was in session of the matter because on 28/3, he was, my lord, hearing.
Hmm.
He was in session of the matter, whether to approve or not to approve. So therefore, the, my lord, legal fiction will not come into play. Because he has already entered into the arena, my lord. Here, my lord, your lordship will see, my lord, the second paragraph. In this connection, a hearing was conducted on 28/3. So this will be a misnomer to say that it was issued after, my lord, expiry of 15.
This hearing was in connection with a complaint. This was not
Maybe,
whether
my
to approve or disapprove the AGM.
Yes, my lord, maybe.
This-
Thereafter,
there-
he
there
had,
has to
my
be-
lord, disapproved it.
There has to be, we have to
No,
be
this
clear,
is a case of disapproval.
Yes, my lord, it's a case of disapproval.
whatever be the outcome, we have to, on the first day, when the jurisdiction was exercised, it was only complaint. And therefore, we had come to the court saying that we were not heard. And therefore, we had gone back below. I leave it to your lordship.
So why didn't you raise that point then? That look here, he has exercised beyond 15 days. Why didn't you raise it then?
The First time,
First time,
he was
first
adjudicating a complaint. He
No,
was
the
not
first
on
time
this.
when you came, why didn't you raise that issue? That he did it.
But so far as my submissions are concerned, 45 is not an embargo to this because rules are there, election rules are there.
Huh?
But I would submit without lordship.
45 was exercised.
Wrong. For my respectful submissions, my lord, whatever comes, but this is a fit case, the lordship, I would pray that lordship would invoke the doctrine of cases submissions. Fill in the missing gaps, read into the rules and the act. Otherwise, it's not, just overall thing is not coming up, my lord.
Heard Mr. S. Bonita, then council is here. The SK Talukder appeals on behalf of the respondent.
For 6.
On number 5 and 6. Five you are appealing. 5
Only
and
for six.
6. The petitioners herein have approached this court challenging the order dated, where is that order?
102.
10. Order dated 21/9/2023. In fact, here dismissing a repetition would amount to allowing it also. We will ask them to do it within 90 days.
Absolutely, that would count,
Yeah.
naturally would count. But the uncontested part, lordship will also take care of that. We elect the uncontested.
Huh?
The election is uncontested. Regardless of the voter list, that point lordship made.
No, no, therefore, I also understand that it was uncontested, but the thing, the problem which arises is that approval. It was disapproved. If it is disapproved, there the problem arises with 27. I don't want to touch much on this 27 now because we'll leave it out there for you to challenge 27.
If the disapproval is under challenge in the writ petition, and I say I was elected uncontested, then lordship may test it on that. If the disapproval is on count of voter list, and I say I was elected uncontested, regardless of the voter list, then lordship may test the merits of the matter on count of these 2 lines only. Disapproval, leaving aside the finesse and the jurisdiction, that lordship is not addressing for the moment. Very well, disapprove. 82 and 102, 84 and 102, only on count of voter list. But voter list is not even required. You elected uncontested, nominations are not under challenge. Nomination has to be challenged. That part, what remains? Even if I take the disapproval to be 45 to be lawful.
Yes, Mr. Talukder, what do you say on this?
Yes,
aspect?
my lord, it's a valid argument, but my lord, I place in this manner. Your lordship will again come to 102.
Yeah.
On perusal of the attendance sheet of the AGM held on 18/3/23, it is found that many shareholders have signed the attendance sheet twice. It is not on voter list, it's on this, my lord, attendance sheet twice. And signatures have also been found against share numbers of dead voters. My lord. Now your lordship will see, my lord, this is essentially related to quorum of an AGM. If the quorum is achieved by fictitious signature, it has to go. You don't know, my lord, how many persons were present?
You have filed your affidavit.
No, my lord, legal sufficiency.
This was never, we had argued it once earlier also, that the registrar did not open his mind as to the quorum being achieved. But that quorum cannot be achieved if these many numbers of whatever wrong allegedly are taken away. I would bow down to that submission. It comes in that way. Discernible materials are not on record, only vague.
Then it will be a case of remanding
It's a remanding.
Lordship,
to that effect. If it is, you are saying about a quorum.
No, well, in respect of his argument. my
No,
lord.
no, understood.
Yes,
But
in
you
respect of
see,
election. my lord.
his argument, you see, the basis on which it was done. One is, he was saying on the other legal point, that it cannot be challenged on the basis of 27 is the only thing which can be challenged or not. But this court is not going to go into that. This court says that the power is there vested to approve or disapprove, they can do so. That the next question comes in is the question of whether there was any perversity in the order, because the limited extent is only for perversity or wrong application of mind, which is absolutely unreasonable. These are the two aspects which I can touch. Now, in the instant case, he says that I am uncontested. So the voters list has no business. You say it is not the question of the voters list which has relevance. In that meeting, there were a lot of people who signed twice. And there is also an attendance sheet wherein dead people are also, signatures are also there. Now the question arises as to did they meet the 10% of the quorum at the election of the total members who were there. Now out here, if we see 18.3, which is where is that 18.3? Yes. Where is the English one? 18.3? Page? No, 82 is your letter. I'm not on that. Where is the minutes of 82? 18.3. Petition should be dismissed on this ground. Tell me, I'm going to dismiss this petition on the ground that it has not been properly given. Oh. Here. Kindly see total annual meeting of the Iman of the session 2020 Iman resolution number 1. How many people were present?
114 on the first day.
Huh?
140 on the first day when there was no quorum.
Then where is the meeting?
I have given in my affidavit, I replied to the affidavit, Lordship, at page 130, para 8,
Page 1.
130 in my affidavit in opposition.
The observer is very clear. The
That's
date,
two to
figures,
equal to
at
nine.
page 82.
Shareholder.
Observer-
113. One.
That's what I say.
What is your page?
At 130 of my affidavit in opposition,
Affidavit in opposition is not page 130.
it's continuous marking.
Affidavit in reply filed by respond number 5.
No, not that, 6.
They say the first day the quorum was not there, correct. On the second day, the quorum was achieved. This is nobody's case, the quorum was not there.
Where is that document? It's very difficult to find it. You have not given the proper, yeah. On this ground only, this court will dismiss your petition. Where page?
82 of the writ petition, the observer.
No, you, this is
observe-
an affidavit filed by, affidavit in reply filed by the petitioner.
The writ petition.
When did you file your affidavit?
Lordship, on 25/6/24.
May 2022. Oh, no affidavit business here.
Yes. Oh my God. Lordship, they have
No affidavit.
they have replied
We have
to this
replied,
affidavit.
we have
They
No,
have-
no, I don't have any. I have an affidavit by respond number 5. There is no affidavit of respond
they
number 6.
replied to my affidavit also
Very good.
Yes, yes, ma'am.
I have not received. When did you file?
on 25/6/24.
No affidavit business.
But so far as the figures are concerned, the observers made it clear at page 82. Not disputed by anyone. Page 82 of the writ petition, the observers report made out. Page 82. First day column was not
Now, what is the total strength?
2269, 2299. 2299. And it says 10% is.
How do you
230
know
required.
2299?
Page 82, for a moment, third paragraph. That's all.
Okay. Now, if the voters list, and how many persons you are saying that the voters list is bad, madam?
Lordship,
How many persons voters list have not been entered?
Lordship, Lordship, I have stated here, only 359 persons attended the meeting which they showed quorum was completed. Where it had that person's name, I have annexed certificates here. Those people are already dead, but they
It's okay, I'm not on there. How many persons should have been the persons,
in the quorum.
as per you, whose name have been excluded in the voters list?
Many, Lordship,
No, not many. You can't come up with a many business out there.
That-
You must have submitted an application. This application has to be specific as to who are the persons concerned.
I had submitted an application prior to the election, saying that the voter list was not corrected as per the act and the rules, and the elections are going to be held. That was my contention.
Then you can't give a submission and vacum. It has to be based on facts. In your affidavit, did you say that how many people actually should have been eligible voters?
I said 40% names are incorrect in the voter list.
So there would be less.
There would be less.
So then the less it
No,
becomes
no.
better for them.
That's not there. There'll be
Then
more.
what do you say?
There'll be more. There'll be more voters.
There'll be more.
If the voter list were hanged,
Let's see your complaint.
$45.
The first paragraph is wrong.
40% of the members of the have already expired and the voters list is also to be yet to be prepared. Such without preparing new voters list, protection will not be. So if 40% have expired, the eligible voters would become less. This is your the thing. Finally see page 45 of the writ petition.
Yes.
So, so which should have been 2,200, 300, they are saying, remove 40% from there as per you.
But they have to be replaced by the share,
That is not your case in your, this is memorandum.
no, Lordship. The thing is, once your voter lists are corrected, Lordship will come also to on
At paragraph 13. it
page
says
20,
that-
page 110 3H of the rules,
100
110H. Sorry, 3H, page 3H of the rules. Sorry. It is. Conduct.
Elector means any
No,
member
no,
whose
Lordship,
name is.
that- In the rules, rule 3H.
of elector.
There is no 3H.
In the rules, Lordship.
3H, the concerned chief executive secretary of the society shall prepare and submit a list of members eligible to vote on the election as per section 26(3) of the Act.
Yes.
And to the register authority for conveyance, the registered society and the joint so and so. Concerned in exercise of the delegated power of the registrar shall ensure correctness of the deleting the dead voters. Incorporation of new voters. Now, where is your statement that there are incorporation of how many new voters?
No, once the death release is given for notification for correction, those who are dead, they'll be in, their shares will be taken up by their concerned representatives. There may be their high and legal heirs and everything. This is the rule. It's once that it is dead, it doesn't go away. The share will come on the legal heirs.
So then 2,300 will
Yes,
remain.
yes,
So therefore, the shareholding
yes,
has to be to the extent of only 2,300.
lordship.
Okay. 359 were already there. Okay. So 359, there is no finding of fact that how many people were there. You can't come up with in such a vague manner.
But
No,
this is,
Mr. Edwards
no,
will not be able
my
to
lord,
take it
I have
next time.
submitted, what I'm trying to say, my lord, the election and the AGM, because if your lordship comes to 54, this is the proceeding. And my lord, in resolution saw non prostab. By way of this resolution, my lord, it is resolved that these are the persons, my lord, who are elected. This is, my lord, part of the resolution. So
Page
now,
50,
page 54 is the resolution of the AGM, my lord. 54. And if your lordship comes to the relevant part,
show
that
me
is
which
at
is the
page-
English. Yes.
page, my lord, 79, saw non prostab. It starts from saw non prostab. And if your lordship comes to page 8,
Page
page 80, my lord,
80.
80. Last part, my lord, বিজ্ঞপ্তি অনুযায়ী, that second part. বিজ্ঞপ্তি অনুযায়ী নির্ধারিত সময়ের মধ্যের কোণে কেনে প্রার্থী মনোনয়ন পত্র প্রত্যাহার করে না করায় সর্বমোট 14 জন প্রার্থীকে বৈধ বলে নির্বাচন আধিকারিক ঘোষণা সমিতির নোটিশ বোর্ডে টাঙ্গিয়ে রাখেন মোট 15টি পদের জন্য 14 জন প্রার্থী দিস এন্ড দিস এন্ড নাও মানে সমিতির 22 আর 23 ইংরাজি 26-27 ইংরাজি পর্যন্ত কার্যকরী সমিতির সদস্যবৃন্দের নাম নিম্নরূপে বর্ণিত করা হলো। Well, this is the resolution. Now, once, my lord, this entire resolution is disapproved, all this.
No, 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 no. You have the power to disapprove. There's no quarrel with that. But you have to exercise the power within the limits of law. You can't do it on just mean, oh, these voters legal. You are to come to a finding that look here, the attendance seat, there has to be a basic reason. When it is an uncontested, you had the quorum, there is no mention out there, there is no quorum. How does the false, it is just a vague assertion being made in the impugned order.
And we pleaded that in
I
paragraph
think
13.
you not filing the affidavit, we set aside. You may have, you may not
I
win in
have
the
made a-
case, but on facts, he has a case.
Lordship, to satisfy this court, I have made a list and I have annexed here. The people who are dead, who are shown to be voting, they have shown to be present on the day for voting.
How many?
Lordship,
How many?
only-
That is your thing.
I also made a statement. only I-
Madam, how many? Does it go below 230? That's the question.
We pleaded that in paragraph 13.
But before the election.
No, no,
They've
not,
No,
in-
that's-
I'm not concerned about that.
Yes, Lordship, 1 minute.
Whether your name was there or not,
Mine was-
your name was there or not in the voters list. So who are you? Who are
I'm
the,
a shareholder, Lordship,
understood, but who are you to come up out there? Why didn't you contest the election?
because this election was not notified. That is my case. There no notification was
Huh?
given.
Then it is the fault of them. You didn't notify.
It is notified by the secretary, man. Secretary notifies, secretary.
Notified.
No, not only that, the returning officer also does.
No, my lord, your lordship will come to 33. This is issued by my lord secretary. Notice is by secretary, madam.
Understood, but then also you are to do it.
We have to issue the returning officer. That's a different aspect. Notice by the secretary, madam, not by the department.
Lordship,
That has been duly, you see, the authority did not touch on that aspect.
What I'm saying.
No, 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 no. The authority did not touch on the notice. On the question of notice, the authority did not touch.
No, correct. My lord, what I am submitting that it is issued by the
And
secretary.
her
It is
case,
her case.
where's her affidavit? I'm not getting that affidavit.
speak, sir.
Get her affidavit to coach. I'll by one, respond number 5.
Six.
phone number
At
6
least
to
some- at
পাইছি
least six ideas.
6.
No problem. I don't know who is that. You know, typing mistake. The one. Typing mistake. Here's my opinion. Mistakes, so like.
Observer is your person. Unless you categorically have stated that why it has happened. With these attendance sheets, would they have affected the election? That is the important aspect. You'd have said that yes, 159, how much does it take for becoming below 230? It has to be 230, 10%. So how much does it take? Minus is 359
My one is not.
minus 230.
Nine.
9,
Nine, eight.
2, 1.
My one is
129 fake. There has to be 129 fake or dead persons. Unless that is not there, nothing. No, in a case, why should they score?
No, Lordship will also go to the prior to the election, the rules to be followed to make the voter list. We have to be given opportunity, the others to.
Just give it.
It is not, it is not. I'm challenging that only. They never hang. the
You are not before this court. You are not before this court. You are a respondent.
If they have anything, Lordship, they should be going, they should file this election petition before the concern.
Why? They have won the election.
Cannot. Yes, they have won the election, the race.
Show me your representation, anything where you have said that 129. We are concerned that 129 bogus people were there.
Yes, Lordship, the thing is this.
Why
prior
should we
to the
remand it
election,
also?
what we did, Lordship, it's a very simple
On
case,
that-
Lordship.
No remand. Why remand?
Lordship, the
Anyway, I leave it to you.
No, they no, you see, there has to be a basis. Yes, there might be a long, first of all, one has to understand that if he had gone into the question of notice, it would have been different. If it is a case of notice, they should have challenged it, which they have not. Then 27 striking. If it is a case of, just for example, it is a case of 129 people were there, and these attendance would have otherwise materially changed the election. If these words were being used out there or anything to that effect, it is on the
Lordship.
face of it is. Is it their submission? They are saying that for 40% of the people's name has not been incorporated, rightly so. But are those 40% before this court? None. Why? If none of them are before this court, or none have submitted the representation, they are also, they may be legal representative. Who is she?
Lordship,
Are we in a, is there any public interest litigation cell out there, the register of property society?
Lordship, my case is this, Lordship, my dear me.
You, madam, you had a very good case, but the case is not supported by documents.
Lordship, there was another 20 people who had written to the Secretary Manipur Krishna, but this petition is not in the file. It's not put in the file by the registry. I had filed, because they had already filed an answer to my petition.
Those are nothing, we have only against respondent number 5.
Not for that petition, Lordship. Now complain
You have
against,
filed a petition.
and to the answer to their, I have given reply to their affidavit.
You have filed an affidavit in
Yes, in
opposition.
opposition, yes.
Now, do you say in your affidavit in opposition as regards 129?
I say, had that voters list would been corrected, that thousands of members, shareholders would have come to vote.
Understood. But those thousands are not, have not participated. Only 20, let us assume everything, 23. 23 would have also not materially changed anything.
But will all the rules and the bylaws will be passed before, when the voter list is prepared, Lordship,
So why
Lordship,
didn't you challenge it? There is the election you should have immediately challenged within 3 days. Why didn't you do?
before that they are here, before this, did not appear in the first count, the petition, the first day. There are
No, they came later on after 3. I'm not on that. Why on till 21st you did not challenge it? You ought to, or that was passed on 18-3. You should have challenged it by 21-3. Why didn't you challenge that election? You were very there. You can't come up. Anyways, the company. List this matter. I've substantially heard this matter. List this matter again on Adikitari 29. Nah. List this matter on 5th of September. Was taking into account that the affidavit filed by the respondent number 6 is not on record. The registry shall Miss P submits that the affidavit has been filed on 25/6/2024. 25/6, huh? Registry shall look into the same and bring it on record. 5.
Lordship, may I pray, Lordship, a different date is given, Lordship. There are 2 matters fixed already on.
Okay. We'll have it on 31/8.
Lord,
31/8 at 2 p.m.
no,
31.
Saturday is a working day. Yes, it's working day.
Matters, my lord.
Oh, yes.
Cancellation of mining lease which my lords were dealing.
Yes.
State wants to take time to file counter.
Sir, I received some instruction, my lord.
We'll take up the matter when the turn comes.
My lord.
This is what? Yes.
May I please have us?
Yes.
My lord, these petitioners, my lord, admittedly, these are government lands, my lord. We have been there in possession for, my lord, some, for 25 years, 27 years, my lord. And at the same time, my lord, we have been, given GMC holding number and we are paying, property tax. My lord, we hold that.
Mercy petition.
Sort of,
Yes. When are you vacating?
my lord.
When are you vacating? It's a government,
Yes.
it's not a government land, it's a railway land. When are you vacating?
My lord, we need some time. I will take
How much?
instruction.
How much?
Tomorrow, they are,
No, tomorrow we'll give you some protection. How much? 3 months? 3 months. Take it,
my lord,
file an undertaking by tomorrow. Break it within 3 months. I give you a protection.
my lord, can it be little longer, my lord? Because
Otherwise, Lordship, the central project is on the,
Yes.
we are going to construct the particular. project.
You understood,
Lordship.
but then also they are in possession of this for a long time.
Lordship,
You
3
have
months I
one
have
fine day,
noticed.
issue the notice very well.
Lordship.
You see, in other case, if I issue a notice out there and I have to state,
I have,
which may not be in your interest, so.
regarding this case, Lordship, as per Lordship's proposition, I have no objection, Lordship. Petitioner have to give the undertaking. before
Yes, by
Lordship.
tomorrow.
Lordship, we have to be undertaken.
List these matters tomorrow. And heard Mr. T.H. Hazarika, the learned counsel appearing on behalf of the petition, as well as Mr. K. Gogoi, the learned counsel appearing on behalf of the petitioner. Respondent. Gustav. The instant proceeding, repetition. Gustav. Issue notice making it returnable on a little bit the day after,
Lordship.
31, on 31/8/2024. Mr. K. Gogoi appears on behalf of all the respondents and accepts notice. Gustav. From a perusal of the the petitioner herein have filed the instant writ petition challenging the proceedings under the public premises under the what act? Under the Public Premises Oblique Eviction of Unauthorized Occupants Act 1971. On the ground that the land in question, where the petitioner have been in possession for the last many years, is a government land. This court have duly taken note of the judgment passed by the Additional District Judge number 1, Kamrup Metro at Guwahati. All are dated same.
my lord was, 3 and 19, my lord, appointment. I'll just point out.
Yeah.
3 and 19.
Wherein there is a specific finding to the effect that the land in question is a railway land. Under such circumstances, this court prima facie does not find any illegalities in the order so passed in the proceedings so initiated under the Public Premises Oblique Bracket Eviction of Unauthorized Occupants Act 1971, as well as the judgment so passed impugned in the instant proceedings. Mr. T.H. Hazarika, Learned Counsel, submits that as this petitioner has been residing in the in the land and has a dwelling house, some time may be granted so that the petitioner may search for alternative accommodation. So on the other hand, Mr. K. Gogoi, Learned Counsel, appearing on behalf of the Union of India, submits that that the said lands are required for infrastructure projects which have been stalled on account of the petitioners. This court, taking into account the said submission, is of the opinion that the petitioner, that the eviction of the petitioner cannot be stalled. However, may be deferred by giving some reasonable time for them to vacate. This court shall only consider subject to a specific undertaking being filed before this court by way of an affidavit as to whether that they would vacate within a period. How much? 2 months. Eh?
3 months.
3 months.
May I pay for some more time?
More. Make it 2 months. Within a reasonable time. Full stop. And not more than 3 months. Full stop. Mr. T.H. Hazarika, the learned counsel, submits that he would file such undertaking, the petitioner would file such undertaking. Full stop. Taking into account the matter is fixed on 31/8/2024. This court states the eviction of the petitioner till the next date. Full stop. It is, however, made clear that if no undertaking is filed on or before the next date, that too by way of an affidavit, this court shall then take up the instant matter for disposal on that date. The registry shall list this matter at the top of the list.
Respect to item number 1, 2, and 4, Lordship, order date is 31/7/2024. And Lordship, in respect to item number 3 and 5, Lordship, 19/8.
File your affidavit, undertake.
Yes. Lordship, right. Actually, that method, Lordship, 132 high voltage. electricity
Yes.
Running. Lordship, we had filed one affidavit yesterday, Lordship, morning also, we made a mention for requisitioning the affidavit, but it has not come due to some, I don't know, Lordship. We had filed one affidavit stating that it is not 2 meter from the boundary. It is actually 30 feet from the boundary where they have erected the,
So it is not in the middle of the road.
it is in the middle now,
How middle?
30 feet from the boundary, Lordship.
So it is outside the boundary?
Inside, from the boundary, inside the boundary, it is 30 feet. 30 feet inside the boundary.
Where is your affidavit?
Lordship, we had filed one affidavit yesterday, Lordship, maybe for the time being, Lordship.
You have a copy?
I have a copy. We have stated at para 3.
And the village road, what have you written at paragraph 3? That it is categorically stated that the electric towers of the poles are erected at a distance of 30 feet inside the boundary of the petitioner and the village road.
At our boundary, there is a village road, which is 6 feet village road. So from the boundary and also from the road, it is 30 meters inside our plot,
Oh, I have asked the, yeah,
30 feet. We wanted to have some instruction. Lord. A report of last Mongol will suffice. I think.
Paragraph 6 is.
As of now, construction has not happened.
Construction, they are continuing because of stay of this honorable court. They have stopped it as of for now, Lordship.
Has there been any construction?
One pole they have already erected. According to them, they are supposed to.
Now, is your land under, does your land have a boundary wall?
Wall is not there. Wall is not.
And how is your land bounded?
Boundary, but
How?
the place from which the road starts, there is no boundary.
Yes, yes.
There is no, in fact, no boundary.
Then how do you say that it is within your land? You are saying in the middle. The circle officer's report says no, it is outside. It is not within. It is 2 feet. I'm not getting this aspect of the matter. It is saying that 6 feet wide road at the boundary of the land of the petitioner, which is used by villagers. The construction work of the 4 pillars have been done from a distance of 2 meters of the said village road. Is it towards the petitioner's land or out beyond the petitioner?
Towards the petitioner's land. Towards petitioner's land.
Towards the petitioner's land, but from the 6 feet road,
It is 2 meters. There is a 6 feet road. Thereafter 2 meters gap. Thereafter they have constructed that pillar. That construction has been done.
and then the petitioner's land.
Petitioner land starts from the village road process. Petitioner's land starts from the village road process. So it is in his land also. That construction has been done in his land. And
Ah.
there is no dispute that he is not willing to give that land. He is willing to give that, and everything has.
But
been
it
done.
is not in the middle of this land. Because how, you see, there is, as I could understand from all this, there is a 6 feet road. And from that 2 meters will be another 6 feet. 6.6 feet. And the village road is there, then there is a boundary wall.
That, other side.
Why you are bringing the concept of boundary wall out here if it is within this? Let us see this page 36 of your document. Page 36, annexure A3. Do you get it?
We have shown this boundary wall because that.
Now tell me. This is the boundary wall. Where is the village road?
There, after boundary road, this blue color line also that is.
This is the road. Now then petitioner's land is this side.
From that boundary wall, village road, his land starts also.
From the village road, his land starts. Now you are having these 4 pillars in his boundary road. How much is the extent of this?
This is not
9 meters.
6 meters.
No, it's 9 meters. See,
What's 9 meters?
9.868 meters, which commensurate to around 27 feet. 32 feet. So this is 32 feet and then another 32 feet. So it is around, you are using most probably around 32 into 32 would be around.
Almost 8 places of land is we are
Mhm.
all together in 2 pillars, in 2 towers, we are taking 8 places of land from him also.
Okay. 8 lectures.
Places of land.
So you are taking 8 lectures. And how much is the land, breadth of the petitioner's land?
Is almost, my lord, 60 feet.
Huh?
60 feet,
60 feet
yes.
is your breadth.
It is entry point. Thereafter, it just like U-shape. When my lord survey was done, they have decided to erect the poles on the left side of the my lord boundary. But they have erected the my lord poles on some other portion. So I think when the survey report is also required in this.
Survey they have said, which goes against you. That is why I'm asking you. And where is your house?
My lord,
And how much is the area of the petitioner's land total?
9 bighas.
What?
9 bighas.
9 bighas of land. This is our 8 acres of land. You are saying that the middle. My goodness.
My lord,
breadth of the land actually. It is just like,
So are we to understand that your 9 acres of land is just 64 feet?
my lord, poles were erected here, then my lord, the whole electricity where was passed on the middle of the land. So my lord.
It can't be on the middle of the land, it will be on the side of the land. It can't be on the middle of the land. How can it be in the middle of the land? Middle of the land if no area of land is left.
Apart from that also, that electricity line is coming from other side also. If it is, suppose it is come from this side and he is giving his land towards this side, again it will go here, again it will go again. It is not possible. It will go straight also. That is why they have erected this post.
But at the time of survey, what they actually, my lord, decided to erect the poles, they are not erecting the poles on the same place. They have erected the poles on some other pole, the other side.
And
Mr.
already one
Council,
post has
you will
been
be
erected.
entitled to all the benefits, whatever you claim it out there before the district judge. Whatever loss is felt, claim it out there. That how much is your loss? As of now, you have not taken the money, I'm told. You have not submitted any document. So you do it if you want it, or you may very well challenge. That is the only way out. Heard Mr. S. Chaudhary, the learned counsel, appearing on behalf of the petitioner. Mr. P. S. Lawford, the learned standing counsel. Learned counsel, learned CGSE appears on behalf of the railway department, as well as Ms. S. Borua appears on behalf of the district administration. The incident with petition has been filed by the petitioner seeking directions upon the respondent not to direction upon the respondent to carry out the construction of the 132 kV transmission line over the plot of land of the petitioners covered by DAG number 396 or Patta number 3 of village number 1, People Pukuri, under Moja Hockey, Lonka Hojai. After completing acquisition procedure and with little damage as possible, that is erection of poles towards the boundary of the land and not in the middle of the land of the petitioner, and pay full compensation in terms with section 10D of the Indian Telegraph Act. Full stop. I've heard Mr. H. Chaudhary, the learned counsel appearing on behalf of the petitioner, submitted that the construction which the respondents, more particularly the respondent number 5 and 6 are undertaking would result in constructing in the middle of the land of the petitioner and thereby would render the land of the petitioner useless, and as such appropriate direction be passed. On the basis of the said submission, this court on an earlier occasion directed the respondent authorities to file the affidavit and also passed an interim order to maintain status quo as regards the land of the petitioner. Pursuant thereto, an affidavit has been filed by the respondent number 5 and 6. In the said affidavit, it has been mentioned that the construction work has not been carried out at the middle of the petitioner's lane as claimed. It has been stated that there is a 6 feet wide village road at the boundary of the petitioner's land, which is used by the villagers and the construction work has been done, bracket, that is for the four leg pylon, PYLON, bracket close. Keeping vacant a distance of only 2 meters from the said village road, and that too for safety purpose, which is essential as the said tower would be used for electrification. It has also been stated that apart from keeping vacant the said area for safety purpose, no land has been misused. To support the said statement, a foundation drawing of the location number 29/0 have been enclosed in the annexure 3. From a perusal of the said annexure 3, it reveals that there is a boundary wall and thereafter there is the 6 feet road, village road. Further to the 6 feet road is the petitioner's land. And an area of 8 lessons have been taken for the purpose of construction of the tower, which is in an area of 9.68 meters into 9.68 meters.
Yes, sir, for both the tower, not only one, for both the tower.
And then 8 lesser for 2 towers. To be constructed in an area of 9.68 meters into 9.68 meters each. This court had further put a specific query upon the learned counsel appearing on behalf of the petitioner as to what is the area of the petitioner's land, to which the learned counsel submits that the area is 9 bighas. It is also seen that on the last occasion, on 22/8/2024, when the map instant with petition was listed, this court had directed the circle officer, Lanka Revenue Circle, to submit a report as to whether the electrification is carried out in the middle of the petitioner's road. Today, Ms. S. Burua, the learned counsel appearing on behalf of the respondent, district administration, have placed before this court an instruction dated 28/8/2024, which is kept on record and marked with the letter X. From the said document, more particularly at paragraph number 6, it has been the stand which have been taken by the respondent number 5 and 6 have been reiterated. Under such circumstances, this court is of the opinion that no, the question of interference under such circumstances, as the construction which prima facie appears from the materials placed before this court does not appear to be constructed within in the middle of the petitioner's road land. The question of interfering with the said construction work does not arise. Be that as it may, this court, however, observes that the view taken herein is on the basis of the materials which have been placed. The loss which have been occasioned to the petitioner on account of construction of the tower, transmission line, construction of the towers and the running of the transmission line running over its land can very well be agitated before the district judge. Hojai. Shankar Devnagar Hojai. By filing an application under section 16(3) of the Indian Telegraph Act 1885. If the petitioner is aggrieved with the amount of compensation so awarded, accordingly, this court, while not interfering with the work carried out, the construction work carried out, directs the respondent authorities to release the due compensation to the petitioner upon the petitioner submitting the necessary documents and after submission of the necessary documents and proper verification. The same be done within 15 days from the date of submission of the documents by the petitioner. If the petitioner is aggrieved by the amount of compensation on account of the loss suffered, the petitioner would always be at liberty to approach the district judge, Hojai, Shankar Devnagar at Hojai, within how much time? 45 days from the date of the funds being disbursed to the petitioner. With the above, the instant petitions that disposed of, the interim order so passed earlier stands vacated. Hearing at us, yes, what is this?
May it please your lordship. One of the writ appellants,
I think I always agreed with this corporation department. Yes. Tell me.
Well, 7 of us are before your lordship.
Huh?
7 of us are before your lordship. We were declared winners uncontested. But there were 9 total. Valid nominations were 9. So we can take 9. 7 are before your lordship. Now, 10 others whose nominations were cancelled after scrutiny had approached the authorities by filing an appeal under 27.
10 have approached, no, 10 did not approach, 5 approached.
No, 10 approached. They filed 10 approach. But they broke up their approach in such a way that 5 of them were rejected with the remark C, ABC, quote unquote. Cancelled. The C is there. Against my name, C is there. So they say out of their 10, 5 of their names have been discarded with the name C, with the letter C. 4, there is no C, although rejected. That is wrong on their part. I've calculated it is 5 with C and 5 without C. They did it wrong. Anyways. Now, while arguing the matter before the authority concerned, they pressed on only the 5 with C. They did not press the ones cancelled without the remark C. Eventually, the authority held that this is bad. The proceedings book is not there. These 5 names were rejected. For those years, proceedings book is not there. So it is vitiated. Our case is, for 5 preceding years, you have to attend the meetings, 2 meetings. Even without those 2 years, we are through. 3 meetings have to be made. Even without those 2 years proceeding rules also, the writ petitioners would sail through. It is not their case that if those proceeding books are not taken into account, our nomination would be invalidated.
No, I understand. I heard this matter. No?
My lord. Lordship,
See,
because
if I recall it correctly, you have total 15 board of directors. 9 were validly elected without any election. 5 or 6 were rejected, or 10 were rejected, whatever may be, of which 5 did not challenge. 5 challenged it before the authority. Now, your case is, whatever may be, as regards the 9, they could not have set aside the entire thing. What they could have done is to hold election in respect to the others. That's your case.
but when they file the affidavit as it's following from your lordship, whether 5 of you have filed the appeal or 10. they've
No,
got-
I asked them to come up with this code, no? Appearing on behalf of the shall also get instruction as to who were the 5 shareholders whose candidates were rejected in terms with section 42 of the Act.
They were 10. If lordship takes up the post title, I can indicate who's were rejected with the remark C and who's without the remark C.
Where?
The post title at page, I can indicate the names also.
No, they see here, page 26, where? Nomination of so and so.
Page
A
26.
accepted, these are all accepted.
The last
Please
one,
see.
Jaminuddin Laskar is C.
Number 10 is C.
And there is one, Riazul Haq Mazumdar also.
There is nothing.
There is no C.
Then,
Then page 28. Admitted, withdrawn are there, but rest are there without C.
page,
28.
these 11 to 18.
Well,
So what is A? WA?
accepted, accepted.
WA is accepted.
A is accepted, WA is withdrawn.
These are withdrawn.
Withdrawn. A is accepted.
So how many had withdrawn? 1, 2,
The numbers
3,
are
4. 4 has withdrawn.
6 has withdrawn total.
Where? 1, 2, 3, 4.
No, in the 26 also there are 2.
Understood. 26 is there, and here only 2 are there.
Here 2, 4. And page 32, 2, 6.
How many have participated?
My lord, the total participation were 27, out of which 9 were accepted, 12 cancelled, and 6 withdrawn.
Page number 36, madam. 36 is the calculation.
Weaker section,
8 accepted, 4.
8 accepted, 4 withdrawn,
Six
6 cancelled. Okay, stronger section, 4 cancelled. Women section, 2 withdrawn, 2 cancelled. ST 1. Okay, so there is requirement of a woman also. That is was his submission last occasion.
Yes.
But whatever may be, still it is open. How many are filled up till now?
9, madam.
You have still 6.
Yes, still 6.
So 6 can be held.
We are, my lord, 10. We are 10, my lord. Here, my lord, 6 plus 4, 10. We are 10, my lord. Cancelled, my lord. Page number 36. This clearly mentioned, my lord, 6 plus 4. These are, my lord, a male,
The
10.
total is 12. Cancelled
Yes.
is 12.
12. 10 plus 2, madam.
10 plus 2 is
Yes.
cancelled. Okay. Now, how many have challenged this?
10, madam. 10.
So out of these, the weaker section and the stronger section have challenged it.
Yes.
So they 10 have challenged it. Let's see your appeal memo.
But they have pressed for 4, 5. They have not pressed for
Let's
10.
see the appeal memo. Where is the affidavit?
Yes, before the registrar, my lord, we can challenge, my lord.
Where is the appeal? Yes, Mr. Which were the 10?
Page number 68, my lord.
Huh?
Page number 67 is
67.
67. That's my affidavit.
No, there is no affidavit between 67, yes. There's one, yes, there's an affidavit
From 68, my lord,
under 27A.
Yes.
An appeal was filed.
from
By,
68, from 68, my lord,
oh, appeal has been filed by 10 people.
yes.
Then,
They have not pressed for five.
well, how do you say so?
We say so from page 79, paragraph 11, the last part. Conjointly, I read with the impugned order.
Yeah.
The last part, 4 lines from bottom. May I read? The name. The name of 5 appellants with remark C and other 4 appellants without any remark have been affixed on the notice board of the society. They break up into groups. And in the impugned order,
The appellant's nomination has been rejected, while the nomination of respondent number 71 has been accepted. Then,
they break up into 2 groups. One group with the remark C and the other group without the remark C.
how do you say that they have not
The
challenged?
name, now I'm coming to that. This is how they break up into groups. But when I take the order at page 51, the impugned order, many times we make prayers, my lord, we do not press the prayers. We press in parts.
Uh,
Page 51, may I read that? In pursuance of the petition filed by Nurul Haq and 9 others of Mohanpur Sahabai Samiti Limited to so and so advocate on 28/4/23 regarding the voters list and alleged illegal cancellation of nomination, 5 numbers of appellants on the grounds of violation of section 42 of the so and so and so and so and so. That is the case. They're pressing on 5. It is not a typographical error.
Typing
It's-
error, my lord.
It cannot be, Milo. They're pressing
no,
on
no,
5.
no, no, no. This can't happen there. That cannot be a ground. What is the reason here?
Reason is
line
the proceeding books were not there.
documents submitted by the applicant. Then, it is the order. Yes, what do you say?
As per the instruction, the appeal was filed by
9.
my lord,
Appeal was filed by 9.
10.
10.
Ten.
Then,
10 has filed the appeal. So the register says, my lord, page 52, the type copy, it would not be ascertained, my lord, whether those persons, my lord, were in fact, they were legally, my lord, disqualified or not. Those could not be ascertained.
Now, all these nominations of these 10 persons who filed were rejected under 42. So everybody have challenged this. Because they are specific saying that all these nominations were challenged under 42. Cancelled. That too without a proper voters list. There
No,
was
but for-
nothing done under
In the absence
26(3).
of original proceeding, in the absence of original proceeding.
Huh?
In the absence of original proceeding, my lord, the registrar could not ascertain whether these 10 people who are present or not in the last two, out of the 5 into general meeting.
Yes, any other ground?
We say even without these 2 years, we are there for all years, so this would not make a difference to our nomination.
No, no. Then somebody may not be there because they are 9.
Correct. He was proposing that even if this lot goes away, nominated, elected, there can be election for the rest.
Understood, but that is only 15. How do you accommodate the 9? They are 9 in number.
Yeah, but for the rest of the thing, 6 now. As I could understand, my lord, so far as their rejection of nomination is concerned, but this will have a bearing on the valid nominations been declared of our group. 7 plus 2, 9. 7 before the lordship, 2 are not. 9. Now proposition subject to correction, my lord. If this 9 is allowed to be valid, then for the remaining 6, they can have an election.
How do you do about the 9? Then you see, then if these people, the election would have been properly accepted, then 3 of you may not have been there.
One view,
That is the only way out.
but he would be also proposing to that the rest would contest for the 6.
Huh?
Subject to
No,
correction.
no,
what he
that
said.
would have been possible. When you submitted earlier that it was 5,
Yes, fine.
other 5 have already voted, means they have given up their appeal.
But
Then
it appears so
would have
from the
been.
order, my lord.
Understood, but the
Then
order,
they got present by-
but there is nothing on record to show that this order may have been.
5 were for pressed and 5 were not pressed.
Let's there is another, they may have
Page
wrongly.
36, my lord, clearly mentioned that 10 persons nomination, my lord,
Yes.
cancelled, my lord. Clearly mentioned page 36, my lord. So our 10, my lord, cancel nomination is cancelled, my lord. In the director's order, it is maybe it is typical error, my lord. that-
Third, Mr. S. Bonik, the learned counsel appearing on behalf of the commission. Mr. S. K. Talukdar, learned standing counsel for the corporation department appears on behalf of the respondent numbers 1, 2, and 9. Gorman, okay, none. Mr. M. J. Kadir appears on behalf of the respondent numbers 10 to 19.
My lord, as per section 41(9), my lord, if there is vacancy, my lord, arise, then my lord, it can be filled up, my lord, by election, my lord. So, my lord, 41(9). So, if, my
Understood.
lord, our nomination is held to be valid, my lord, then, my lord, election may be held for these 10, my lord, valid nominations.
6.
But
6
how do you take care of a situation if you want to give up?
He's
Then
giving.
you have to give up for
he's
3.
gi-
Are you going to give up?
So, we are 10, my lord.
Understood.
Yes.
So you are saying that these 10 nominations were illegally rejected.
Illegally.
Now, the vacancy which has arisen is only 6.
Only 6.
Then you have to give up 4. Are you going to give up for 4?
Otherwise, my lord, their election, their selection
Supporting
is
us.
also, my lord, will be invalid, my lord.
That is what I am going to make it invalid.
Yes.
But he's proposing, my lord, 6 for the remaining 6, they would contest, 10 would contest.
So you have to give up the rights of 4.
My lord, not in, as per provision of the act, my lord.
No, no, I am saying, you may say to that effect, that 4 does not want, have nothing to do. I believe it.
So they would contest 10.
That is it.
They would contest for the induction. They say
No,
out of
that
this
can't
10,
happen. That cannot be there because then his election has to go. What do you say, Mr. Talukdar? That cannot be
That
done.
cannot be it. So they are willing to give up.
Either this 10 has to be there to that effect.
Yeah.
The authority has come to a finding. This is a question of fact. I'm not going to touch on that.
Yes,
So under such their election, they has to go because they went uncontested.
yes, sir. That is right.
So therefore, the only next course of action is to hold a fresh
Yes,
election.
yes.
The subject matter of the instant writ petition is regarding the legality and validity of the order dated, whether order 6/10/2023, whereby the AGM of Mohan, what? Difficultly. Mr. Boning, next time onwards, your matters, I'm going to take it up, very bad, yeah, you give the Mohanpur CS Limited. AGM of the Mohanpur CS Limited held on 25/4/2023 was cancelled as per section 40(4)(a) of the Assam Cooperative Societies Act 2007. From the appraisal of the materials on record, it transpired that the election notification was published on 30/1/2023. By the Assistant Register of Cooperative Society for conducting the annual general meeting and the election for constitution of the Board of Director of Mohanpur Samaway Samiti Limited for the year 2022-23. Thereby scheduling it to be held on 27/2/2023. Footstep. In the same election proceedings, and pursuant thereto, "27 shareholders submitted nominations, which included 18 shareholders from the weaker section, from 4 shareholders from the, there's a word called stronger section. Stronger section. 4 nominations from women and 1 SC/ST. Pursuant to the same nominations so submitted, the nomination, 8 nominations were accepted from the weaker section and 1 nomination was accepted from the SC/ST section. Two women shareholders who submitted the nomination withdrew, and 4 shareholders from the weaker section withdrew. Full stop. In total, full stop. Thereupon, 6 nominations from the weaker section, 4 nominations from the stronger section, and 2 nominations from the women's section were cancelled. Being agreed, the respondent numbers (10 to 19), 10 to 19 who belong to the weaker section as well as the stronger section filed an appeal, filed an application, instituted an election proceedings. Challenging their cancellation of their nominations. It may be very relevant to mention that from a perusal of the memo of appeal, which were filed by the respondent numbers 10 to 19, it transpired that all these nominations were cancelled in terms with on the alleged violation of section 42 of the Assam Cooperative Societies Act 2007. Pursuant to the filing of the same election proceedings, hearing was held and the learned and the Register of Cooperative Societies by the impugned order dated 6/10/2023 held that the rejection of the nominations of the respondents of the appellants of the rejection of the appellant of the respondent number 10 to 19 on the ground of section 42 was illegal in view of the fact that the violation under section 42 of the Act of 2007 could not be substantiated in the wake of absence of the original attendance register, accordingly, the annual general meeting of the Mohanpur CS Limited, SS Limited, held on 25/4/2023. Is it 25/4? It was to be held on 27/2.
Yes, sir. On that time, the quorum was not fulfilled. For which it was
line at the was to be held on 27/2/2023. Subsequently, however, on that date, the elections could not be held, the AGM could not be held on account of lack of quorum in the in the meeting. And accordingly, the same was postponed to be held on 25/4/2023. Okay. Was cancelled as per section 40(4)(a) of the Assam Cooperative Societies Act 2007. And there was a direction to the Joint Register of the cooperatives. To the Joint Register of the Cooperative Societies, Silchar, to hold fresh elections and to place one-man management to manage the affairs of the society. Being agreed by the order dated 6/10/2023, the instant petition has been filed by the petitioners herein, who are the 9 directors whose nominations were accepted, and and were elected, were declared to be elected in terms with section 13A of the Assam Cooperative Societies Election Rules 2019.
We are seven.
Huh?
7, 8 before your lordship. 9.
I have been approached by 7 out of the 9 directors who were elected. Huh? I've heard Mr. S. Bonig, the learned counsel, appearing on behalf of the petitioner, who submitted that from a perusal of the impugned order dated 66/10/2023, it is seen that although there were 10 persons who filed their election proceedings, but a perusal of the order shows that only 5 persons have pressed on the said election proceedings. In other words, it is the submission of the learned counsel for the petitioner that if the 5 persons who, or if 5 persons out of the 10 persons who filed the election proceedings have withdrawn from the said election proceedings, the registrar by the impugned order ought not to have cancelled the entire election process, but ought to have exercised the power under, ought to have directed for exercising the powers under section 41
9.
9 of the Act of 2007.
Further requirement might be there.
Huh?
Even if lordship dismisses the writ petition relating for a re-election, even then those proceeding moves will be required, which I admittedly lost. Then also nothing, we went back to square one. The requirement of attending 3 meetings out of 5 years is a statutory requirement. They say they cannot be settled aside only on the ground because the 2 proceedings were missing. In any view of the matter, those will remain missing, even for a re-election. Then
So that cannot be to their prejudice. No?
I understand, but
You want the clarification so that they are not later on be.
no, we want it the other way around. We want, since re-election is not possible, 9 goes, and for the remaining, they may have an election. Because now balancing equities on both parts. We have rights crystallized because of this.
Remaining is for the division bench. Mr. M.D. Kadir, the learned counsel appearing on behalf of the respondent number 10 to 19 submitted that these respondents whose nominations were cancelled illegally by applying section 42 of the Act of 2007, which could not have been applied in as much as the respondent, it was the fault of the respondents to maintain the attendance register, which they failed to do so. Full stop. The fact that the respondent numbers 10 to 19 had duly participated, the fact, the rights under section, the right of the respondent numbers 10 to 19 to participate in an election cannot be curtailed on account of the fault of the respondent authorities. Mr. S.K. Talukdar, the learned counsel, submits that in view of the fact that the nomination, learned standing counsel submits that in view of the fact that the nomination, in view of the order passed by the impugned order, if the nomination of the respondent numbers 10 to 19 were illegally rejected on the basis of section 42 of the Act of 2007, the entire election process has to be set at naught, else only six posts of directors would be available, and the petitioners herein would then be considered to be elected, that too without any election. I have heard the learned counsels for the parties and have given my anxious consideration to the respective submissions. From the facts above mentioned, it is clear that in the said election proceedings, 27 persons have participated in the election, filed their nominations. And out of that, six had withdrawn. And 12 were rejected, were cancelled. It is not known as regards from the materials on record, it is apparent that 10 were cancelled. That out of the 12, 10 were cancelled on account of being not held to be not eligible in terms with section 40 bracket 2 of the Act of 2007. Under such circumstances, this court finds it relevant to take note of the said provision. A perusal of subsection 2 of section 40 stipulate that a member of a cooperative society shall be eligible for being chosen as a director of the cooperative society if such member has patronized the services of the cooperative society during the previous financial year to the extent and in the manner specified in the bylaw and had attended at least 2 annual general meetings in the previous 5 years. The attendance of the under such circumstances, what is required is that the shareholder has to attend 2 annual general meetings in the 5 years from the date of filing of the nomination. In that context, if this court duly takes note of the impugned order, wherein the register of the cooperative society had observed that the original proceeding book and the attendance register of the year 2020-21 and 2021-22 have been lost by the secretary of the society on 1/2/2023. The register of the cooperative society further had also taken note of that the Xerox copies which were produced of the attendance register of 2020, 21 and 2021, 22 it was seen that some serial numbers in the attendance register present with the office are blank. Whereas in some serial number, the name of the petitioners in the Xerox copy of the attendance register was available. It was under such circumstances, the Register of Cooperative Society came to a finding that without the original attendance register for the year 2020, 21 and 21, 22 being available, relying on the photocopy of the attendance register would not be proper, and accordingly held that as the nominations of the petitioners of the respondent number 10 to 19 was solely on the ground of violation of under section 42 of the Act of 2017. To which the petitioner, the respondent numbers 10 to 19 cannot prove in view of the secretary losing the attendance register, opined that the cancellation of the nomination of the respondent number 10 to 19 was illegal. The said observations so made, said findings so arrived at, being findings of facts by the Register of Cooperative Society, this court cannot interfere in exercise of its jurisdiction unless there is any perversity shown to that regard. However, nothing could be shown in that regard. And as such, this finding of fact, insofar as the illegality, so far as the illegal, so finding of fact as regards the illegal cancellation of the nomination of the respondent number 10 to 19 cannot be interfered with. The next question therefore arises, which is the edifice on which the petitioner has approached, is should the Register of Cooperative Society direct calling for a fresh election, or should have exercised the power under section 41(9) of the Act of 2007. Mr. Elponic, the learned counsel appearing on behalf of the petitioner, submitted that a perusal of the order dated 6/10/2019 would show that only 5 numbers of appellants have challenged, although there were 10 persons who filed the petition. As would be apparent from the order that impugned the order. On the other hand, the respondent number, counsel, Mr. M.J. Kade, the learned counsel appearing on behalf of the respondent number 10 to 19 submitted that the respondent number 10 to 19 have never withdrawn from the said election proceedings so initiated, so filed. The consequential, in view of the above, what transpires? That if the nomination of the respondent numbers 10 to 19 is held to be valid, if the cancellation of the nomination of the respondent number 10 to 19 is held to be bad, their nomination has to be therefore deemed to be valid. In the cooperative society in question, admittedly, there are 15 board of directors. And if the 10 nominations have been illegally rejected, the question, it is the opinion of this court that the learned, that the register of cooperative society have rightly set aside the entire election proceedings and directed holding of fresh elections. Under such circumstances, this court finds no ground to interfere with the order dated 6/10/2023. This court further takes note of that by the order dated 6/10/2023 by the Register of Cooperative Society, there was a direction to the for holding the fresh election by appointment of a one-man committee. This court further takes note of section 41(6) of the Act of 2007, which categorically mentions that the one-man committee is required to hold the elections within a period of 3 months. 3 months. 3 months. This court also finds it very relevant that the cooperative society, that the spirit of the cooperative society is to democratize, is to have a democratic setup. And as such, any delay in not holding the elections within the mandate as provided under 41(6) practice upon the very basis of the Act of 2007. Accordingly, this court therefore directs the Register of Cooperative Society along with to ensure that the elections to the cooperative society, that is Mohanpur SS Limited, is held within a period of 90 days from the date of the instant order. Because the one-man committee so appointed is also directed who is in charge of the society, cooperative society, is also directed to take effective steps in that regard. With the above observations and directions stand exposed. Interim order stands fixed.
Lordship has not clarified the requirement of 40 subsection 2. Because the proceeding books will remain the same. In 2 years, proceeding books will always be missing. Therefore, their requirement can never be fulfilled in law.
No, their requirement is never been fulfilled. No, their requirement will be fulfilled. 42 cannot be brought in. Don't worry, I'll touch it up. 42 cannot be used in view of the attendance register being not available against them.
That's what I'm telling.
So they would maybe, but they may not be disqualified for others, but not for 42. That I'll add that line.
That is already declared. Lordship says that if the cancellation is fair, then their nominations are valid. That is gone in.
No, it's okay. But then also
Yes.
for next year, it may be required no, while they submit. So therefore, if the attendance register is not there for these 2 years,
Your Lordship's order. will not
understood, but if necessary, I'll make it very clear because tomorrow again this may happen. So I'll make it very clear that 42 cannot be used again because still as you don't have the register, attendance register
Only for 2 years.
for this
So
period.
this,
And these 2 years is enough.
maybe not, they've not cleared it. Maybe not, we do not know. They've taken a hold of this as a handle.
Understood, but these 2 years,
These 2 years.
you only require 2 years. And these are the Yes, what is this?
I have the specified status.
Anybody appearing for the respondent, private respondent?
Name shown, name shown. Name shown.
Okay. Is there an interim order pass?
Yes, okay, release.
Yes, you were asked to submit an affidavit. Huh?
I have received the instruction today.
What is your instruction?
Lordship, to tell Lordship, 1 bigha, 7.5 lesser plan was acquired from the petitioner's Lordship. And total amount is 6,60,000. And they are not willing to accept the said amount, according to the instruction.
Petitioners are not willing. And has the amount been disbursed? Has any amount been disbursed to anybody?
Yes. That amount has been disbursed to the private respondent. The private respondent.
How much?
This Lordship, 19,61,000.
19,61,000.
Yes.
And what is the basis?
That is Lordship, it is in vernacular Lordship, horror mূল্য and জিরাতর বাবদ মূল্য.
Understood, but is it his land?
This is for the Jirat Lordship,
Huh?
not for land Lordship. Not for land Lordship, it is for the house, value of the house Lordship and the Jirat.
Only for the house,
Yes.
not for the land.
Not for.
House is his. House is also yours.
No house. We are the possessor of the land.
There's no house. Well, then he's only giving for the house.
Yes, yes, not for land Lord.
So you do one thing, file an affidavit next week. You need to finish the small matters.
It's interesting, in the bond, they have shown that also land belongs to our area. Owned by the private respondent.
Pursuant to the order dated 26/7/2024. The petitioner has effected justice service upon the private respondent number 6. And in that regard has filed an affidavit of service. Taking into account the above, this court have duly taken note of the said affidavit of service and deemed service upon the respondent number 6 to be complete. Mr. Ngusami, the learned counsel appearing on behalf of the respondent number 3 and 4 submits that he has received certain instructions. So in terms of the instruction as regards the land value, the petitioners were offered some money. However, they have not accepted. It is also stated as per his instructions that an amount of rupees 19 lakhs
210.
61,210 has been paid to the respondent number 6. But the said amount has been paid only in respect to the house and not the land in question. It is the opinion of this court that such instructions is required to be brought on record by way of filing an affidavit. Which accordingly lists this matter on 18th of September 2024. The affidavit be filed on or before 17th of September. Yes, what instructions? Who are these persons? Patadar, Bharat Chandra Ray and Lakhan Chandra Ray. Who are these?
Chandra is the father of the business number 2.
And Lakhan Chandra Ray,
Deepak Railway.
they have lands out there. Pata land. Pure Pata lands. And you are asking for relocation. Why?
Lordship, 11 lectures were given to us, which are within the patta, and we had market areas, we had certain shops which are not within the patta land. We wanted that there are certain shops which were not within the patta land. That is why we wanted.
Understood. But you have land, then why you are encroaching on roadside land?
Lordship, that is my residential area. We are
No,
not,
have it out there nearby.
Lordship, that is not our, this thing, that is not within the patta land. It was a bazaar area which was allocated to us, Lordship. Long back, 100 years back, it was allocated to us.
Which land?
The land from where we are evicted now. Lordship, those shops were there since 100 years. And
Understood everything. But these are roadside lands, so you have to be evicted. There's no quarrel with that. But you have lands. Why you are not having relocating yourself to other lands? You have 4 kata 6 lessers of land, 3 kata 16 lessers of land. These are the lands which your clients have.
Lordship, regarding this, I do not have instructions.
Get your instructions out there because these are lands. Pursuant to the order passed by this court on 14/8/2024, the additional district commissioner revenue had submitted a report to the effect that the land in question for which the notice was issued was served upon the petitioners was a roadside reserved land covered by DAG number 234 located in village Kampur town, Moza Kampur under Kampur Revenue Circle in the district of Nagaon. To that effect, the Chita copy has also been placed to show that aspect. It has also been mentioned that pursuant to the order passed by this court, the petitioners have been evicted. Also. Further to that, it has also been mentioned that upon verifying the records, land records, it was found that a plot of Miyadipatta and Exonia land measuring 1 katha 11 lectures covered by DAG number 353, 801, 834, 835 is under the possession of the petitioners, which is being used for residential purpose. In addition to that, it has also been mentioned that the petitioner may relocate the business on the lands which have wherein the petitioner own, that is DAG number, a plot of land measuring 4 katha 6 lechas contained in DAG number 483 of Patta number 153 of village Kampur town, and DAG number and another plot of land measuring 3 katha 16 lecha covered by DAG number 496 of Patta number 262 of Kampur town. In that regard, the Chita copies have also been placed before this court. Under such circumstances, in that view of the matter, this court finds it appropriate, is of the opinion that these instructions be placed on record by way of an affidavit, so that the petitioners are in a position to revert, is in the position to reply to the same. List accordingly on 23rd of September 2024. Huh? Shorter date. No, he let him file the affidavit by 18th. You file your affidavit by 18th. And list the matter on 23rd of September 2024. The state government, the respondents shall file the affidavit by 18th of September. The petitioner, if so advised, would be at liberty to file the reply on or before the next.
In this matter, the government has filed an affidavit annexing a notification.
Hello, I got the second last page, is the notification of the affidavit. Additional affidavit.
Yes, what is this?
That case, Madam, the whole exercise has been directed to be completed within 4 weeks. Let the matter come up after 2 months.
My
We'll
lord,
know what.
the matter, as of today, the matter has become infructuous. That is what my lord.
This is the third round of litigation. This
My-
is something they ought to have done
My
years back.
lord will come to the pre-application of a
Let us first, yes, Mr. Chaudhary, what is your case?
My case is that, Madam, as per the Act, Section 49 provides for delimitation of the constituencies of Tiwa Autonomous Council. That is supposed to be based on the criteria that wherever there is a scheduled type population of 50% and above, those areas will come within the Tiwa Autonomous Council. They have included, they notified 36 constituencies. Out of those, in 6 constituencies, the admitted position is that the populations, ST population was far less, somewhere around 15%, somewhere 20%. They have forcefully included those in the Tiwa Autonomous Council, which is not permissible. Now, we agitated on multiple occasions. There are directions, repeated directions, one in a PIL, then thereafter in another case by the division bench, saying that you undertake this exercise. This exercise till date has not been done. Finally, now they have issued this notification. The reason why I'm saying that they will have this matter closed, we'll have to come back again.
Now your village is inside.
They have included our villages in these, where the ST population is far less than 50%. I can straight away, Madam, if your lordship will kindly come to page 22 of the writ petition, your lordship will see the percentage of population. And this position is not even disputed by them.
No, last time I passed some order on 8.
Yes, yes, ma'am.
Wherein I've said that the Learned Council for Reference has placed before this court a minutes of the discussion of the cabinet meeting to recommend the inclusion, exclusion of so and so. The said committee, after a threadbare discussion, opined in favor of inclusion of 6 constituencies of so and so, so and so, so and so. The Learned Council, appearing on behalf of the petitioner, submitted that the manner in which the recommendations have been made prima facie appears to be not in consonance with the Act, taking into account that in terms with the amendments so carried out, even the basis on which it is to be done is by taking into consideration the area consisting of the non-contiguous cluster of villages predominantly inhabited by scheduled tribe population having 50% and above as a whole in the cluster and not necessarily in the individual villages. The Learned Senior Counsel for the petitioners pointing out the basis of making the recommendation submitted that in the instant case, the cabinet subcommittee has believed that the majority of the organization and parties are in favor of inclusion of these 6 constituencies, and the was made the basis of the recommendation, and the said has been made. This on the face of it, as per the learned here, is not in terms. Then
But now as soon as your lordship records this, they come up with this notification.
now what is the effect?
Now, they have designated a,
Designated authority shall publish the draft delimitation order, invite claims, comments, views, so and so. But Mr. Dora, how do you say, because his prayer is that his village should not come within the ambit of the Tiwa Autonomous Council. That prayer, in spite of this notification, would it be there or not? That will still be there.
My lord will just come to the prayer page number 32, my lord.
Right?
Page 32 of the writ petition. What is actually this writ petition they are seeking, my lord? Page
32?
Page 32.
No, the first petition.
No, my lord, this is
217, 517?
no, 6657.
No, no, 517?
My lord,
No. I only see 517. Yes, Mr. Chaudhary, have a look at this prayer in 517.
His prayer is very, in fact, we are also saying,
Yeah, his prayer is in 517 is that the petitioner's village should be excluded.
yes, his prayer is very.
Now, how this notification will make it infructuous?
my lord will take up
In fact, our prayer is also, prayer B is same.
6657, my lord. I'm coming with it, my lord. 665721, my lord. Page number 32.
Our second prayer, man. Your lordship will kindly see our second prayer.
Written and directing the authority to carry out the exercise of delimitation of the respect of so and so. It's okay. That is being done.
Second,
The
second,
first
second
part
prayer,
of
my
the-
direct the
Directing
respondent to
them.
take decision with regard to the exclusion of 6 disputed constituencies. So my lord, this after delimitations only, my lord.
So
it
how
will
is it
fall
enforced,
into
sir?
places, my lord. In delimitation, my lord, objections will be, my lord, invited. These petitioners, they will be there, my lord. They can file their objections there. Whether to be included or excluded, my lord, it will be raised there in a delimitation process, my lord.
But how does this writ petition become infructuous? That is because of prayer being. That is the question.
Six constituencies.
My lord, in delimitation process, if, my lord, they are aggrieved, there will be a separate cause of action, my lord. Because delimitation will be done in a due process of law, my lord, by following the act. We are not only with, my lord, 6 constituency, we have gone for the entire 36. 36 constituency.
Very nice. But Mr. Dhar, what you are submitting is very nice. Why is that not a part of your affidavit?
Which, my lord?
But you are submitting that all these things will be looked into by the delimitation where can raise all objections out there.
My lord, that is what we stated in the,
Show me that, where does it say?
my lord, will come to page number,
187.
running page,
Now, 187 is that the document.
document, my lord.
Yeah. Provides the government may alter or amend the order made under section 48. Now,
48.
therefore, the governor is pleased to order that the district commissioner Morigaon shall be designated authorized to determine the territorial limits of 36 constituencies for the general council of so-and-so in accordance with the provisions of this act. And the governor is further pleased to order that the designated players shall publish draft delimitation order, invite claims, comments, views, objections from political parties, groups and individuals carrying out necessary hearings and take necessary actions as may be required for the purpose and complete the whole exercise within a period of 4 weeks from the date of the issue of this notification.
So, my lord, that is what, once, my lord, the process starts. These 6 constituencies who are, my lord, aggrieved, they will have a chance there to say that the percentage of ST is less, so we should be excluded. And suppose, my lord, this delimitation committee doesn't take this into consideration, that becomes a separate cause of action, my lord. But as of today, my lord, there is no quarrel with the prayers, my lord. We have done it. We have said, that is why, my lord, deliberately is a transparent process, my lord. Public objection,
So
political
your
party.
thing is that as of now, we have initiated a process.
Sir.
The petitioners can very well raise all their grievances
Everything
there.
is there. That is
And if that be so, if they are aggrieved, will be a fresh parliament.
cause of action, my lord.
Second prayer, my lord, our specific prayer is that this cannot be included, this should be excluded. That is our whole case.
Understood, but isn't it a question of fact? When there is a delimitation, what what do you say, this delimitation?
It's
There's a term used, no? Delimitation committee.
territorial.
There's to mention a committee, no?
Committee, man. So DC, now DC is the chairman and ADC and all from all these districts, my lord. Was,
But the act says government, my lord. It does
that
not
is what,
speak about.
that is why, my lord, government has, my lord, appointed DC. It is done in the name of the government. And the order is passed by the government, my lord.
And the other mischief they have done very tactfully. They have given it to DC Morigaon. Actually, these areas fall in DC Kamrup.
No, my lord, no, my lord. It falls in Morigaon.
That is why I am saying let this matter be pending.
Yes. Your minute say about these. Where is this? I wrote in my order last time.
In fact, that minute should be on.
Order I have mentioned here. Your metro say the committee after threadbare discussion opined in favor of inclusion of 6 constituencies of Kamrup Metro District, namely Dimoria constituency, Digaro constituency, Khetri constituency, Punapur constituency, Ampri and Longpo Ari constituency in the Tiwa area. Now, what is this means? That is your recommendation.
Yes, madam.
You are going to include this.
Yes, madam.
So if you are including this, it is not the DC Morigaon who will be there. It is not the area. It is he is only made the designated authorized officer.
We can even bring in DC from Tinsukia, my lord. He's an officer of
Or any person
any person, my lord.
having continuous
having the-
in the office.
Office, my lord.
Yes. You can raise only land. You can very well, I think, as taking into his and record his submissions, you submit all your there. That is the only way out.
That is what, my lord, the notification says. That everybody will be invited for publication.
And if you agree, then the next course of action.
That is a separate, my lord. That will be against the.
Sir, because as of now, this court is not in a position to decide on affidavit whether this area will have 50% or not.
That is only possible after delimitation. my lord.
Delimitation commission.
Commission.
Now I commission. It's not a
Commission, ma'am.
committee, it's a commission.
But that is for the parliamentary and
Parliament.
legislative.
Yes.
Here it will have to happen under the act itself. And the act says government expressly.
No, the government will do it through its officials.
Yes.
Yes, my lord. So that is why, my lord, DC, my lord.
So they have only authorized one person to initiate the process. We can do one thing, let this matter be there. We give the lead, the petitioners can very well participate. We'll take it up after,
Let it be after 2 months, man.
in the month of December when the weather cools down. Because the pendency has more effect.
It has no effect.
Heard Mr. I. Chaudhary, the learned counsel senior counsel appearing on behalf of the petitioner, assisted by Mr. A.K. Bulwa in WPC number 6657 of 2021 and Mr. Wenso appearing on behalf of the writ petitioner in the petitioners in WPC number 517 of 2014. In both the writ petitions, the petitioners have approached this court seeking exclusion of their respective areas out from the Tiwa Autonomous Council. While these writ petitions have been pending, an order was passed on 27/8/2024 by an order in the name of the governor was passed by on 27/8/2024 by the Secretary to the Government of Assam, Department of Tribal Affairs, Plain, whereby whereby the district commissioner Morigaon was designated was designated as the authorized officer to determine the territorial limits of the 36 constituencies for the General Council of Tiwa Autonomous Council in accordance with the provisions of the Tiwa Autonomous Council Act 1995. Mr. Ardhor, the learned counsel appearing on behalf of the Tribal Affairs Plain Department of the Government of Assam, submitted that in view of the said order, the petitioners herein can very well submit their claims, comments, so that their areas be not included within the purview of the Tiwa Autonomous Council before the designated authority. And as such submitted that the instant writ petitions have become infructuous. On the other hand, the counsels appearing on behalf of the petitioner submits that the pendency of the instant writ petition would not affect the proceedings to be initiated on the basis of the order dated 27/8/2024. However, the learned counsel submits that if the repetitions are held to be infructuous at this stage, the rights of the petitioners would be affected. This court have duly taken note of that as per the order dated 27/8/2024, there is a direction to complete the whole exercise within a period of 4 weeks from the date of from 27/8/2024. Under such circumstances, this court also is mindful of the aspect that of the submission made by Mr. Ardor that the petitioners herein would be at liberty to submit their claims, comments, etc. before the designated authority. Accordingly, this court fixes this matter again on 4th of December 2024. In the meantime, the petitioners, if so advised, can very well participate in the delimitation proceedings before the designated authority.
For objections, etc., they have got a right, they can object there.
So I've said that, let them do it.
And your office of pass the order. Otherwise, 3 prayers they have made, all 3 relief.
Understood, what is there? Why do you need the disposal so soon?
My lord will record the name of the addition, my lord will record the name of Epiano.
Later on, after the completion of the order, Mr. D. Majumdar has come. Should I record that?
And I was on leg 6.
Then don't come up with all these submissions. Goodness. For this matter, yes, what have you got?
But on that day also I have pointed out to Mr. Rocky, for fairness, at least there should be an inquiry by the district judge. And
No, I therefore ask them the records on the basis of which they say that you are an NDA militant.
they, but after killing, they will have to bear no other alternative, they will claim like that one.
That's just page number 8.
Huh?
Page number 8.
It is everything in their hand, my lord. Case number 8 and they're all explosive arms and ammunition, projected production, recovery.
Who died?
Nelson, my lord,
What is his name?
his name is my lord. Nelson Gayari.
Nelson Gary. And when did this incident happen? 2016.
2009.
When did the incident happen?
24/12/9,
2009.
yes.
This is a report of 2019. Where is any document to show prior to that he was
The 24/12/2009, there's some GD entries there.
What GDNT? On the basis of GDNT, you hold the person is there. You kill him. My goodness.
There's ambush also.
Tomorrow you file an FIR against somebody and say that he is a terrorist out there, he has the you kill him. You assume that he is a noted terrorist. Can't do that. Now here it says, and he was wanted by police and army. Where? What is the basis of the police wanting him? There has to be some materials on the basis of which you can come to an opinion that this person concerned is an NDFB militant. Where?
In the entry report, they have mentioned.
Where?
The
Where is the
24
intelligence report?
report is not there.
What? And when was the incident? 25/12.
24/12.
24/12. This GD entry is of 25/12.
24/12 is also.
Huh?
24/12 is also.
These are all, no, he died on 24/12. The GD entries are 25/12.
One day later.
Then,
One 24/12 entry is also real.
not 24/12 entry. 24/12.
Yes.
After having shot him, that
No,
is
no, no,
what.
not before, but
So on the day there is a GD entry, you go and kill him.
in the GD entry is some intelligence report is there.
Huh?
Some intelligence.
The intelligence report has to be placed before this court to substantiate. You cannot come up with all these things. FIR based on confirmed and provided by our source and collaborated by CISU movement so and abuse was laid down so and so. Is an abuse. On being challenged to the halt, these suspected individuals started fleeing and operated here. This can't be the reason why. No materials. After killing, you can't come up with all these things. You say in course of investigation, the dead bodies were identified as so and so and so and so. As per record PS, both the deceased persons were NDFB cadres and involved in various international various. Which various? You can come up various. Show me from here. Is there any various way before 24/12? Bhuraji, Madam Bhuraji. Show me. You can come up in this manner. These are serious human rights violations. Did you approach the Human Rights Commission?
No, we have not.
Human Rights Commission may give you more money.
No, but they are giving less money. In many judgments, I have challenged the judgment of the Human Rights Commission. The High Court has NST.
But this is the case. More money. You can't kill somebody. You have not filed your affidavit also. My affidavit
They are
is filed.
fine. In short
You can't.
affidavit, there is none. There is no
No, there is
material.
nothing of it. Who's the Lehok? What do I do?
Enquiry clause.
What inquiry? Who is going to hold an inquiry? District judge.
Punitpur. Punit.
Now, if they are not able to produce anything, why there should be an
Yes,
inquiry?
that is also.
Why? Five lakhs, 10 lakhs? Who killed? Army. Army. Now, have you made the army a party?
They are not.
I'm just there.
We do not
No,
know who has
who
killed.
was the
but
cultivator as per the
paramilitary
era and died on account of a crossfiring between army and NDFB military. Now,
army
what is your basis of asking from the state? State, what you are asking for?
our message is that we are not a band organization member.
Understood. On what basis you are asking for money?
Compensation.
Ex gratia.
Ex-gratia.
Under what scheme?
Usually, but if
Oh, that one.
3 lakhs rupees.
3 lakhs.
But here it is not under that scheme, it will not come.
Why?
If a non-extremist killed, my lord, it will not come. It will be more, my lord, money. Suppose a man has been killed, my lord, without his fault, nothing has been done. And my lord, this way, so many precious lives have been lost, my lord, by the.
No, understood. But if that be so, there is a scheme, but you are blaming the government. But it was died because of a crossfiring between the army and the NDFB. And NDFB is not army is not a party.
No, we the labor, we do not know who has killed, my lord.
That is
They
your
have brought
specific-
us the dead body in
No.
our home, the police,
No, that is your
and to
specific case.
identify this. Is it
No,
your
you
son?
say there was an abuse between The husband on coming to, was coming to the so-and-so. While coming, there was an ambush between army and police party and the NDFB. And in that ambush, there was a firing from both sides. And in that firing, the husband of the petitioner died accidentally due to air. The said air in darkness as reported by the police. In this firing, 2 persons died, including the husband of the petitioner, so-and-so and so-and-so. The ex gratia will be paid where? Under what provision? Those earlier things are not there. Those don't come. There are 2 notifications, na? 2003.
Yes,
Did that come? No.
it will also not come.
In page 19 also, here, there is a file one representation.
When extremist kill, my lord, then this scheme will come.
Huh?
When extremist kill a person,
This is a case of extremists also, no. Army.
army, that is police.
So
paramilitary
therefore the problem arises with the army now. Because you categorically say ambush between army and NDFB. If that is your case, then without army, how can I pass an order?
But how can I know who are the regiment, who are the army? It is very difficult for a lay person to find out.
So in his application lawsuit, page 19.
That is I am looking into it. Make union, I think without union, how is it possible? Unless you come in something, how can I ask them to pay?
Page 19 is by represented to the secretary to the Government of Home Department.
Understood. But you categorically say that it is with the army and NDFB. There's no way mention about the
But
state.
army came in to serve the Assam police. They are the joint operation.
Where?
Yes. It was a joint operation. Army is helping the Assam police during the extremist violence.
Army killed. The innocent person in the ambush between army and extremists.
That is true, man.
Then how do you bring the state government? State government will say that no, we are not bound at all. Although he has not taken that plea, that's a different thing.
Moreover, it is the duty of the state to protect their human lives. The state government has failed to protect me. Whether I have been killed by the paramilitary or Assam police at a time.
Difficult. There is a problem arises. Think about it. List the matter again on 12th of September 2024. On which date Mr. obtained certain instructions. Think about it. How do I do? I want to
No,
give
no,
you,
but
but
I
only
appreciate
thing,
the
how
point.
do I? How do I give it? Because the moment I give you, they will come up with say, look here, I'm not there. It is his own representation. It is the army and the NDFB. We are nowhere out there. Why should we pay? How do you take care of that situation? Tell me.
When operation takes place, like when army goes, when I take the case of Mizoram, Nagaland, but it is very difficult for the common people. Who is the regiment? Who are coming? Who is the captain there? And it is difficult, equally difficult to make them party also. Those
This
aspects I
happened
leave
in
you to Honorable
2009. It would be very difficult to ascertain.
responsibility is very true.
Very difficult. In fact, that day when I was taking up, I told you the matter requires to be should have been taken then only. When you move the matter, when the matter came up before me on the last occasion, I also told you, na? It has,
That's why the
I
inquiry.
forgot to say. In the meantime, the respondents shall bring on record the documents which were placed before this court today by way of an affidavit. Yes. We'll have it on not on 12, 19th.
Right.
19th. Yes, what is this?
Yes, Malad may produce their earlier order 1710 of 23, Malad.
17th?
1710-2023.
What is this? The long
The
order
percentile order,
confinement.
Malad.
I'll
Particularly
also
paragraph 6.
clarify in the additional affidavit where the remaining 14 lessors of the is situated, taking into account the land which have been mutated in the name prior to the settlement operation in Yuan was 2 bighas. whereas a joint reading of the Chitta of so and so showed that the land, total land to be 1 bigha 4 kathas. What is your case?
Basically, my lord,
Is that the
is
original
my
owner of
patha
the
land.
land was Jadunath Bora and Devumiki when he's speaking, and on the pursuant thereto raised the sale deed and so Devumiki had purchased the plot. Sale deed, Yes.
My understanding, madam, the petitioner has come before your lordship, praying for a direction to declassify the land. Already affidavit has been filed by the concerned circle officer, madam, saying the land in question are government land, madam. And they are claiming that they are entitled to that. So meaning thereby, madam, their own prayer is, madam, for declassification of the land. So in that respect, my respectful submission before.
What is this declassification of
Yes,
the land?
from my lord, your lordship, will you kindly see the preamble? Perhaps for conversion, my lord,
What conversion?
from government land to his, my lord.
No.
Your lordship will kindly say.
No, I have to look into it. He
Paragraph-
specific,
page-
no, Mr. Goswami,
My
that
lord,
is not
once-
the case. I've heard
once-
this
once,
matter
my lord,
earlier.
Page 15, my lord.
I've seen this now. He's asking for the whatever words he may use is immaterial. The question here is the land was purchased in the name of the petitioner's
Yes.
mother. It was mutated, but during the settlement operation, 2 darks were made, of which 9.93 R is in the name of the petitioner. However, the other dark, 15.03 R, was made government.
Yes.
That's it.
Yes, that is right, my lord.
How did it become government?
Right now, the land which are under possession of the petitioner, my lord, this is in the name of the government.
How?
I'm not, how that part is.
No, that is how, because
That
it
is
is,
why
it-
he-
absolutely, it is the fault of the authorities.
My lord, the authority
How
has
can the
taken,
authority do that?
authority has taken into account, my lord.
Has the
Therefore, that
authority filed the
is
affidavit?
considered, my
No, Mr. Goswami, has the authority filed the affidavit pursuant to my order?
lord. Oh, that part.
that
of
is
course,
incomplete,
I-
my lord.
Huh?
My lord has asked specifically to produce the record also, my lord.
Ah.
They haven't produced any record.
Have they filed the affidavit?
Yes, they have filed, but
Where is
it's a vague manner, my lord.
Where?
1/2022 and another one is 2024.
2nd of February 2024.
3rd of February.
Yes.
For area Bipin Gogoi, I am discharged as the circle officer.
This is the
The
repetition, my
perusal
lord,
of
of
the
the earlier
regular
affidavit.
which was received by the man, the new government dark number has been originated from dark number 1495. Fourteen originated from dark number 1495 1 2 6. As per the last staff, it is assumed the land located one without the land located total. In the government. What happened to this duck?
Which one?
2890, you have it with you.
Yes,
You got the patta.
yes.
9.93, you have it. Now, you are concerned with 2980.
Page 7.4, wherein I have got 15.03 R. And 2890, my lord, 9.30 R.
No, 2874 is a government duck. Now,
They have made the government, yes, my lord. Percent to,
2890 is here.
yes,
And that is in your name.
yes,
And the other is 2874.
Yes.
This has been made government.
both are made government, my lord. Yes.
2890 also.
Yes, my lord.
No, there's a patta number.
Yes, I would, this is, that is what, my lord. It's a patta land, my lord. It's a,
There is one patta.
yes. Two,
Is 2890 is the dark number in
Yes,
that
sir.
patta.
yes,
Now, whether dark number 2874 has a patta,
yes, my lord.
show me that patta.
My lord, the Jamabandi of the old,
No. Show me the patta. 298.
yes, yes. My lord, originally the dog was 1236. 1236 is the original dog. I have the mutation order also is reflected in the Jamabandi copy, my lord. The old Jamabandi copy, 57. Then, my lord, what happened in 2009 resettlement operation, my lord, they they made two dogs out of the 1236. One is 2890, one is 2874, my lord. And
Where is patta number 298? Where is patta number
yes, I have,
298?
yes, I'll show it.
If there is a patta against the dog, it cannot be a government dog.
That's correct, my lord.
Where is the patta number 298? You must have got it during the resettlement operation.
Well, when it is made government, government, when it is made that the dog is Sarkari dog, my lord, there is no patta, my lord.
That I also know. Then
Lord, prior
I
to
am
that,
asking you, where is dog patta number 298?
yes. Okay.
You are looking into very old papers. These papers are not there.
Well, also the Lord, order of the circle officer, my lord, of the relevant time.
Forget about the circle officer. Where is patta number 298? I'm asking you the
Yes.
simple question. Where is patta number 298?
So what happened, look, earlier, it was a district head as patta number 1, my lord.
If the patta was Nishmi Khera's patta, my lord.
Mr. Counsel, I think I know these facts.
Yes,
First, it was, you have purchased, it was purchased by your mother
yes,
by the deed of sale.
yes.
The dark number was 1236 of Nifira's Patta number 1. During the resettlement operation, it was bifurcated into 2 darks, of which one dark is dark number 2874.
Correct.
And it is not the, and other is 2890 of KP Patta number 298. Now 298, if there is a Patta, means it is a Patta issued to you.
Yes, my lord.
So 290 is that land. Now, if we see page number 96 of those documents which the circle officer has filed, it categorically shows the trace map.
Yes.
That 2890.
Yes.
Whether this 2890 is a government dag or a patta number.
Now it's government, my lord. 2890 is a government dag.
Then where is the patta? Why you are mentioning about some patta?
No, my lord, when it's a government dag, my lord, perhaps
Really?
patta will not be there.
Then where do I write about 298? How did I write about 298? You must have stated something.
Yes, my lord, I have stated, my lord, in my petition, my lord, para 8, my lord, kindly come to para 8,
Then
paragraph 8, my lord.
you must have stated that.
Yes, I have stated, my lord, paragraph 8. Page 8, paragraph 8.
No, where did we get 298? Somewhere it has to be there. Otherwise, where will I get 298?
Yes, my lord. My lord, we come to page 60, my lord, for a moment, my lord, of my read petition. Page 60, my lord. And this is the, my lord, draft Sita. Herein, my lord, kindly see, my lord, Nishmi Khera's patta number 1, Khera's Mehdi 298.
Page?
Page 60.
No.
Originally, my lord, dag number 1236. It was, my lord, bifurcated 2790, 2890. Then, my lord, corresponding to Nishmi Khera's number 1, down below, my lord, Khera's Mehdi 298. Then what they did, my lord, after the resettlement operation, they had deleted my name, my lord. And you see, there is a mark.
So this patta was never given to you.
Yes,
Patta was not given to you.
it was given to me.
Where?
Patta copy.
Did you get the patta during the settlement operation?
No, we have not issued. We have not issued after the settlement operation.
So you have not got the patta.
Not got the patta, because they have made this Sarkari, my lord. And they say, my lord, 225, that the ceiling case, it was the 1236 was a part of the ceiling case. But never in the Jamabandi, my lord, nowhere it is to be seen. That dag number 1236, my lord, the remaining land is intact as per their
Ceiling
record.
under what provision?
Hello?
Ceiling under what provision?
No, they say, my lord,
Ceiling will be on the basis of some provision. It can't be on the thing in air. The ceiling would be under the Assam urban area.
yes, yes, yes.
Urban area ceiling,
Urban
and
area.
that has already gone for a 6. So
yes.
there cannot be a ceiling.
Circle officer report also says so, my lord, because they have not maintained any records regarding that.
Mr. Goswami, you ask your circle officer to superimpose the original trace map with the present trace map in respect of dark number Nifira's patta number 1 of dark number 136. Then you will get where it is. In fact, that was what I directed on the last occasion when the counsel who was there, I asked him, because once you superimpose the original this, map with the new map, then you get where it is.
So, if may I say so, my lord, what perhaps, my lord, the mistake was done regarding, my lord, the ceiling case, my lord. There is another numbering
Gone.
1, 2.
Ceiling has gone for a 6. You see, first of all, in Guwahati, all the ceilings have gone. There's nothing remain. This comes within the Guwahati area, so nothing has happened on. And how much land have you had? The ceiling has to go before that. Ceiling would have gone in 1970. When did you purchase?
73, my lord. 76. No, 73, sorry.
73 you purchased. Prior to that, it was 71.
Yes, my lord.
It was sold. The this court have duly taken note of the affidavit which have been filed by the circle officer pursuant to the order passed by this court on 17/10/2023. The said circle of affidavit is, however, not satisfactory to the queries so raised by this court. This court fixes this matter again on 23rd of September 2024. In that regard, the circle officer, Dispute Revenue Circle, is directed to submit a report before this court after superimposing the new map pursuant to the settlement operation upon the old map, trace map, in respect to dark number 1236 of Nifkira's Khiras Patta number 1 of village Batkuchi under Beltola Moza, and submit as to where the said land being dark number 1236 of Nifkira's Khiras Patta number 1 is presently situated and what are the present dark numbers.
May I please? Lordship, in this case, what happened, Your Lordship, on 18/6/2020, the husband of the petitioner had expired due to drowning. But as per the police report also supported, husband of the petitioner had died due to drowning. But affidavit filed by the respondent number 4, Your Lordship, there is some contradiction, and in this regard, Your Lordship also directed the respondent number 5, that is.
Oh,
Yes, Lordship.
click on this.
For clarification, Your Lordship.
Drowning.
Yes, Lord. And they have already filed affidavit, Your Lordship, if you will find at page 36, Your Lordship.
Then
As per their version, Your Lordship, the husband of the petitioner has been died due to drowning. There is no plot at the time of incident occurred.
due to
Drowning, but there is no plot at the time of incident occurred, Your Lordship.
then
Their version was. that-
I said that there was a contrary picture because the officer in charge was
Yes.
helping you.
Lordship, as per the officer in charge. But he has already retired, Your Lordship. So I was relied on judgment passed by the coordinate funds, Your Lordship.
What
Judgment,
does it say?
as per the, in WPC number 4438/2021, Your Lordship.
What does
Your
it say?
Lordship will find at paragraph number 13, Your Lordship, at page 8. Down below, your worship. Similar situated matter also, worship, the honorable coordinate bench already disposed. There was, this was minor, your worship. He also died due to drowning in river. As per the notification 15/11/2024, river is a public place, your worship. So my humble submission before your worship, this case may be considered as per this notification. Because the deceased was the sole owner of the family, your worship, the husband of the petitioner, your worship. Due to absence of this deceased, your worship, the family of the petitioner has been.
Huh?
In absence of the husband of the petitioner, your worship.
Mercy petition.
Yes.
Then what?
Like,
Mercy, I don't have time to make mercy petitions. Mercy petition has to be on a good day
your worship.
in the morning hours when I am a bit more merciful. Not now.
So far as that's a
It's the matter again on 18th of September.
Yes.
These matters are not for Tuesdays and Thursdays.
developed.
Yes, what is this? Yes, Mr. Bhattakur. No affidavit.
Lordship, our judgment has been recently pronounced by this honorable court, Lordship.
Oh, that one.
Yes,
So this is that point.
yes.
duty.
Which one?
Is it in my, what I thought about?
Yes.
My opinion that the moment it is brought out of the manufactory, the liability will be there.
In fact, your Lordship has heard this matter also.
Oh, yeah.
at length.
No, that is what.
Yeah.
I was holding that opinion, then the matter went out from me. Yes. Then what it means? Nothing.
But Lordship, this is only addressing the part of excise duty. With regard to VAT, Lordship, there the finance department's view of the interpretation would be required. Lordship.
This was a case where the commissioner permitted destroying.
But for excise duty, Lordship, whether sold or unsold, Lordship, that can be levied, Lordship. That is what.
Because of the fact that the moment it is brought out of the manufacturing, the liability is there, and because of it is the bonded warehouse, no?
Sir, it's about it.
Yes, what is your case now?
My lord, lordship may see the last annexure, my lord.
Hmm.
There was a committee which was constituted, my
With
lord.
reference to the demand, the following excise officers are hereby directed to examine the matter to the Barak Valley Swansea and submit a report to the undersigned. What?
Yes, but my lord, not submitted, my lord.
For report for what?
For what they were supposed to inspect the go down and all of that, my lord.
Or why?
To assess now, the what is a consumable item and non-consumable item, that has to be assessed. my lord.
Then for what?
That's what, my lord. That
For what
committee was-
purpose?
Purpose is that, my lord, to come to a finding that, my lord, what is the actual total consumable items, non-consumable items. And
Let
also-
us assume that it is not consumable, then
But with the one process they have initiated, my lord, that has to come to a logical conclusion also, my lord.
let them do it. We vacate the interim order.
That can be.
Let them also start it. We vacate as regards the state excise duty tax.
My lord.
Excise duty I vacate, but not the VAT. Because you see, unless it is brought out and sold, you are not liable. This is post,
This is
this is for which period?
two part, my lord.
And this is for before the new rules came in.
Before 2016, nah?
16.
Before
Yes.
the 2016 period. Then the stay as regards the government, the finance remains, would be there.
They were supposed to, my
Because
lord,
there cannot be a sale,
yes, they're gonna be seen.
there's sale. So therefore that is okay. But why you are approaching this court?
But,
Where's the threat?
But if, threat is that, my lord, whenever the license is to be renewed, my lord, we deposit a huge amount of money is been, we are depositing and they are renewing our license, my lord.
Then what is your threat? Why you are asking that?
Lordship may see that, my
The
lord.
application for renewal of license shall be considered by respondents without taking into consideration the fact that the excise department has not completed its report. So the report has no relevance.
But they have to.
As of now, the report has become redundant in view of the judgment of the coordinate bench.
But for VAT maybe lordship. that
VAT
could
is
be
okay.
there.
That is okay,
But for duty.
but
it's not.
why are you challenging? One submits that they apprehend that there will be some problem in the renewal of the license from 2023-25. You got your license renewed. Huh. You do, withdraw,
Lordship-
withdraw,
Lordship
and
give me
next
one
time
day my lord.
liberty, next time to approach.
Lordship will give me one day time, my lord, to look into that.
No, it's okay, but I think you have got your renewal, then why
No,
you are
but
pressing this?
every time, my lord, it happens, my lord, that
Every time
they
you
demand
come.
money for
It's
that.
good for Mr. J. Roy. Your prayer is very specific. Non-renewal of the license for the year 2023-24. Then what it means? Impugned order so and so passed by Iman directing AR to be. Oh, there you want to stay.
There's
Okay.
no course of
So
action.
this we vacate it. Stay the impugn. There is no the tax demand. Because there cannot be a tax demand. I remember why. The government categorically had said that they cannot, the Commissioner of Taxes have stated that there cannot be a tax demand. However, the audit put an objection as regards the Commissioner of Excise saying nothing.
This was lordship with only with regard that case lordship. Here I have not come across any such communication by the commissioner.
Now they actually want this stay. Ad valorem levy of
Yes.
amounting to this on saleable in a year. Where is the demand? 23/9/2016? How can you say this?
The final demand measure notice.
Is he paying still the excise establishment there?
Oh,
duty?
that is not our case, master.
That is also lordship now based on this interpretation now. Because after this judgment lordship, with regard to unsold stock, their dues are pending now because they will have to clear their dues for unsold stock. But again, lordship, VAT is also involved. VAT, unsold lordship probably not, but without finance department's view.
When do you want it? No interim order extended, huh?
Next week, my lord.
You have already got your extra, yeah. And the interim order was only for this. Not extending this paper. When do you want it?
Anytime, my lordship.
Okay. List this, at the request of the Learned Council for the petitioner, list this matter again on 18th of September 2024. Mr. Ibotak were appearing on behalf of the Excise Department, placed before this court, judgment of the coordinate bench of the coordinate bench in WPC number 196/2019. Dated 22/8/2024, wherein the learned coordinate bench had opined that the bonded warehouse which existed prior to 1/7/2016 would be liable to the excise duty in respect to all unsold goods and unsold stocks, whether it was consumable or not. Taking into account the above, this court, Mr. J. Roy, the learned senior counsel submits that he would like to go through the state judgment. In that view of the matter, list this matter again on 18th of September 2024. Full stop. There's no interim order now.
There's no course of action.
Okay. The interim order so passed on 29/3/2023 stands modified in view of the order passed by the judgment passed by the coordinate bench in WPC number 196 2019, and the said order shall now be, the interim order shall only be limited to VAT, to the VAT demand on non-consumable stocks.
Problem.
Yes, what is this? Buying 4 matters. Why are these before me?
Non-payment of bill, Lordship.
Non-payment.
Lordship.
Non-payment is not my bench. It is the matter before appropriate bench. Non-payment of dues is not my bench. There's bench 4 matter.
My lord, herein, the alleged contender had taken a stand, acted apparently in contempt, but subsequently filed an affidavit stating that that was by an error of judgment.
What they have done? Be that as it may, this court also finds it relevant taking into account the resolution in the meeting is required to be state pending decision on remand. This court have done so taking into account the serial will ensure if the said resolution is not state pending disposal. Accordingly, the board's resolution of the cooperative society state in the outcome of the appeal prepared before the register of hearing. Then what happened?
So initially, my lord said.
The register is further directed to dispose of the said appeal within 15 days from the date of remand. Have they disposed of?
Appeal was disposed, but prior to disposal of the appeal, a situation arose that who would continue as the chairman and secretary. In terms of my lord's order, an officer had written that yes, the earlier set would continue in compliance of the High Court's order. But the alleged contender had passed an order revoking that order. So that was allegedly, we had filed an active contempt. Now the stand has come, and subsequently when notice was also issued, there was a.
Now what happens? Infructuous.
Now, absolutely.
Heard Mr. This is an instant, the instant contempt of proceedings is directed against the order dated
25/7.
judgment and order dated 25/7/2023 passed in WPC number 4083 of 2023. Against the alleged willful and deliberate violation to the order dated, so judgment and order dated so and so. It has been submitted at the bar that the alleged violation is no longer exists. The alleged infraction no longer subsists, and accordingly, this court, accordingly, this court closes the instant contempt.
Right.
Lordship, this IA is filed.
Is this I business?
Lordship,
I for what?
Lordship, this IA is filed for alteration, correction and alteration and modification for the
What?
order dated 29/23 passed in WBC
What
249.
you are asking is what?
Lordship,
Correction of? Where? No, where is the mistake?
can you see the annex, sir?
Where? Page?
19. Lordship.
Where we made the mistake?
Lordship, para number 4. Very Lordship. This court filed on an order
Think
dated
that this court has specifically directed to file an affidavit here. However, the affidavit has not been filed on a granted time to file in here. Then what?
Revenue Department, it is ought to have been the
What? This
implementation.
court directs the commissioner and secretary, Government of Assam, to verify whether there is any scheme for grant of ex gratia amount to the next of the martyrs of Assam agitation, and if such scheme exists, does petitioner be disbursed an amount of rupees here within a period of 4 weeks from the date a certified copy is served upon there. Then what happened?
Lordship, it is ought to have been implementation of Assam Accord Department. Lordship. Implementation of Assam Accord Department. But it was directed to the secretary to the government of Assam, land and bureau.
We have received an instruction, Lordship, from Joint Secretary Implementation of Assam Accord Department that the dispersing authority is Assam Accord Department.
We do one thing. Issue notice, making it returnable on 23rd of September 2024. Miss P.R. Mohanto appears on behalf of the respondent number 1. Miss S. Borua appears for the respondent number 2, 3, and 4. Good stop. This is not required, na? Assam Marty is not required, na? Trust?
No.
Do you have anything to do with the trust?
Not required.
Good stop. So taking into account the direction sought for by the instant application, this court is not inclined to issue notice upon the respondent number 5. Full stop. As the respondent numbers 1 to 4 are duly represented, extra copies of the instant application be served upon them by tomorrow. Full stop. On the returnable date, the council shall bring on record the stand as to whether any correction is required to the order dated 20/9/2023. Madam, on the next date, you tell me that it should have been this, and then I will correct it as my making a review. Because by this IA, actually, he should have filed a review.
Obliged, Lordship.
Wait, please.
Here's what happened. You are still on technical points. What is this?
Kindly go through my instructions. I received.
They were supposed to file it on affidavit, yes, so they can't hand over. Can I have a copy?
You get it, don't it? Giving an opportunity of being heard in this hearing.
Can I have a copy, please? That's fine, I know, but then if you handed it over to the court, then it's. It's fair to give me a copy.
I'm also good.
But these are there, Mr.
Yes, my
Chowdhury, but the question is whether these have actually received by the petitioners.
Actually, what I am getting, my lord, from this, my lord, he has not received these things, my lord, but that was not clear, my lord. One, your lordship is kindly go to 17 June 2020 letter, my lord. It was intimated, given an opportunity being heard, my lord. But if so I want to file an affidavit, my lord, vetted by the law department, so that I can bring before your lordship for the other excellent.
No, you, by these documents,
Yes.
you duly agree that 4A is compulsory.
Yes,
There cannot be an exception.
they have, my lord, because 10A to B of MMDR Act, my lord.
All are understood.
Yes, my lord.
But your specific, from this document, one thing is very clear, that section 4A is mandatorily required to be followed.
Yes, my lord.
And you duly gave an opportunity,
Yes, my lord.
but they did not appear thereafter you have taken the decision.
Yes, my lord.
The fact that whether you are in a position to show that you have served upon them this notice is a question.
So absolutely correct, my lord.
And
So-
if that be so, why should I trouble this court with such big litigations? And set aside that order and asking them to file the reply on that date before the authority. we take it up next week. Let him also get something. You just, this is the instruction. If you want to file an affidavit, you may. But the fact
sir,
is, huh?
Correct, your lordship, correct.
Because the matter needs, you are the best person to decide.
Yes.
And I know what is their decision would be because of the fact that without the mining license, you cannot.
Yes, my lord, that is the case.
I know that, but on the other hand, 4A is also required, and you admit that 4A was issued, but the fact that 4A was not served upon them is also true.
Lordship is correct, my lord. Exactly this point, that is why I want to file an affidavit whether he received or not. That is the point.
There.
So
Then
he
if you
will
want to
also
file an
next week, my lord.
affidavit, whether he received it or not, that is, I give you.
Necessary, my lord. Set aside the
May I just clarify? In their affidavit in the other matters, they have a specific amendment that this was not served. Kindly see that, man. Please see, my lords, the affidavit that they filed in the earlier first, my lords, how I
No,
got
no,
to
no.
know.
First of all, why I'm not taking, why the other matters have not been listed
My
today?
lords, they are listed. Man.
Yeah, list
They are
all the
listed.
Where?
All the matters are listed.
Isn't And what about the other matters?
other matter has been listed, my lord.
Because your order,
Yes,
this order is also based on that.
yes, ma'am.
Because their license having been cancelled,
Yes,
because
ma'am.
there is an interim order proceeding.
Yes, ma'am.
So something has to be done there also.
Yes,
We do one thing, we fix it on some day when it was available on 24th of September. We finish it off.
24, my lord, I have some person.
Okay, 24th, I'm also busy. 26th.
Yes, my lord.
In the meantime, you want to file an affidavit, you file an affidavit. And we take a call on the other one. Other,
Other requisitions available before your lordship.
Huh?
All the requisition is available.
My lords, in the other set of petitions, the pleadings are not complete. Those.
it's okay. The other
Well, as a
matters are-
Union of
these
India has to
2022 matters. Where are the 24?
They have also filed reply.
The Union of
Where in
India-
those matters?
Yes, sir.
Okay, no, we do one thing. We took all these matters up together on that date.
Yes,
In
ma'am.
the meantime, you file your affidavit. What affidavit on this? If you want.
If I want, ma'am.
Or otherwise, you may say that, okay, we are ready to hear them, give him a hearing, and then I fix a date. to
Lordship may
hear.
fix that at 26, my lord. I said.
In fact, my lord, I was just pointing out their affidavit at, well, it's 246. Clearly says that we were not served, my lord. It says.
No, Mr. Sharma, the thing is not
No, no.
that. Let them come up. He
No, no, yes,
wants
yes,
to
of
file
course, ma'am.
some affidavit, let him file it. He has brought the instruction that
Yes.
notice was issued.
Yes.
But the fact whether it was, but one thing is apparent, the section 4 was,
Yes.
they also admit that
It's very-
4 is
My
required.
lords, my lords,
Yes,
it's
ma'am.
rightly
So
pointed
therefore,
out.
the question is, the only way out is to set aside this and asking them
Yes.
to hear on a fixed date. So instead of that, we fix it on 26th of September,
Yes,
if
sir.
they may. But then we take a call on the other repetition also.
Yes, ma'am.
Today, there's no time.
Yes, ma'am.
List the instant batch of repetitions again on 26th of September 2024. Mr. NNB Chaudhary, the learned counsel, the learned additional advocate general of the state of Arunachal Pradesh submits that he would file a short affidavit in respect to as to whether the section 4A of the Mines and Minerals Development and Regulation Act
1957.
1957 have been duly complied with or not. Just list accordingly. You take these papers, you take these papers. Mr. NNB Chaudhary, I've asked the registry to give you that amicus matter, huh?
It's my lord. This is Lakhimpur matter, my lord. I have inquired.
Ah.
Yes, ma'am. I have made an.
Oh, yes, yes.
Lakhimpur matter.
That is the case where that person has died.
Yes, ma'am.
So you have so that the jail manual and all can be.
Yes. I have.
My lord is keeping the matters on the 26th of September.
And you know.
I'm obliged.